Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. I proclaimed last week that Wednesdays are the new Fridays around here, so let's have a great day today. And we will start with Judge Glazer in Miami-Dade.
Estamos leyendo el mismo informe de arresto. ¿Ha leído usted la frase antes de eso?
They went to the kitchen, grabbed a 9-inch long knife with a silver blade and black handle, and approached the victim.
Él fue a la cocina y agarró un cuchillo de 9 pulgadas de longitud con un mango negro y con una cuchilla plateada y se le acercó a la víctima.
But you're right, it doesn't say he made any verbal statements when he grabbed the knife.
Pero usted tiene razón, no dice que él profirió ninguna afirmación verbal cuando él agarró el cuchillo.
And not just that, Your Honor. I mean, obviously that's an act, walking towards the victim with a knife. But just the act of walking towards another person with a knife is an insufficient act to create fear in another person.
Y no solamente, su señoría, esto es solamente un acto de caminar hacia la víctima y esto no es suficiente para causarle temor razonable a una persona.
Miss Atz, you want to you're still
I walk towards my wife every day in the kitchen with a knife. That doesn't mean I commit an aggravated assault.
Yo camino hacia mi esposa todos los días en la cocina con un cuchillo. Esto no quiere decir que yo he cometido un asalto agravado.
So my position, Your Honor, is there would need to be some additional act, such as pointing the blade at the victim, such as telling the court the proximity of the defendant to the victim. Anything like that might rise to the level of making an aggravated assault, but it's not within the four corners of the safe warrant.
Thank you.
Bien, así que mi posición es que debe haber ciertos actos adicionales, como que le apuntó a la víctima con la cuchilla. También debería mencionarse la proximidad entre el acusado y la víctima para poder probar asalto con agravantes. Y esto no está dentro del contenido del informe de arresto.
State, you have a response, or you want to call in your officer, or you want me to reset it for probable cause hearing in the afternoon?
Fiscalía, ¿va usted a responder o quiere que yo lo reprograme para audiencia de causa probable en la tarde y llamar a la gente de la policía para que testifique?
It's the state's position that there is probable cause in that the defendant grabbed the 9-inch knife and approached the victim after a verbal altercation.
La postura de la fiscalía es de que sí existe motivo fundado, ya que el acusado agarró el cuchillo de 9 pulgadas y se aproximó a la víctima después de una discusión verbal.
It was a threat in that the defendant made the statement, if you want to call the police, call them, because he knew he was committing a criminal act.
Es una amenaza en el sentido de que el acusado profirió la amenaza. Si quieres llamar a la policía, llámalos, porque él sabía que estaba cometiendo un acto delictivo.
Also, she went into her bedroom and held the door so he couldn't enter, which shows she was in fear of him.
También ella se fue al dormitorio y aguantó la puerta para que él no pudiese entrar, lo cual demuestra que ella tenía miedo de él.
Mr. Hubbs, I think there is probable cause based on the totality of the arrest affidavit, although you do make a very good argument.
Así que, señor abogado, creo de que hay motivo fundado basado en la totalidad del informe de arresto, aunque sí creo que usted ha presentado un argumento legal válido.
So I have 2 stay-away orders, but there's only one victim. Who's the victim,
The
State?
other victim, I think, is the witness. Your Honor can disregard.
He's not a victim, he's a witness. Who's the witness?
The witness
initials.
is RG. The victim is SMD.
All right, thank you. And Mr. Hubbs, anything else you want to say?
Just on bond, Your Honor, I would request a reasonable bond of $5,000 via no prior record.
Bien, se ha dicho por parte de la señora juez de que ella tiene 2 órdenes judiciales de alejamiento, pero y solamente una víctima. Se ha aclarado que es solamente una víctima y la otra persona sería un testigo con las iniciales RG. El abogado solicita fianza razonable de $5,000, ya que usted no tiene antecedentes judiciales.
All right, so sir, I'm entering a stay-away order from the alleged victim. the initials are SMV.
Bien, señor, estoy dictando orden de alejamiento de la presunta víctima, cuyas iniciales son SMB.
That's the mother of your 7 children.
Ella es la madre de sus 7 hijos.
No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties.
Prohibido todo tipo de contacto con la presunta víctima, ya sea directa, indirectamente, en persona, por escrito, por teléfono o a través de terceras
And
personas.
no contact with the victim through social media or other electronic means.
Y se le prohíbe todo tipo de contacto con la víctima a través de redes sociales o cualquier dispositivo electrónico.
And you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times.
Y usted deberá mantenerse a un mínimo de 500 pies de distancia de la víctima, de su residencia, centro de estudios y de trabajo, y en todo momento.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No se involucre en ninguna actividad delictiva, ni use ni esté en tenencia de ningún narcótico ilícito.
And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Y no utilice, compre, esté en posesión, ni porte ningún arma de fuego, pistola, arma, ni munición.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Usted debe entregar de manera inmediata cualquier arma de fuego, munición o permiso de porte de arma oculta a la estación de policía más cercana a usted y presentar el comprobante en el tribunal.
And you may return to the victim's residence one time only within 48 hours of your release from jail.
Y usted podrá regresar a la residencia de la víctima solamente una vez y dentro de las próximas 48 horas de su liberación de la cárcel.
You must be accompanied by a police officer
Usted deberá ser acompañado por un agente de la policía
so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork, and work tools.
para que usted pueda recoger su ropa, sus medicamentos, sus documentación personal y empresarial y sus herramientas de trabajo.
If you go to the victim's home without the police, or if you stay there, you will be arrested.
Si usted va a la casa de la víctima sin la policía o se queda allí, usted será arrestado.
Do you understand the stay away order, sir?
¿Entiende las condiciones de la orden de alejamiento, señor? Yes.
Thank you. What, we almost said a bond? How long has he lived here in Miami?
¿Hace cuánto que vive usted aquí en Miami?
23 años.
¿Cuánto? No lo escucho.
Como 23 años del 2005. No sé
All right.
cuánto.
Since 2005, like 23 years.
All right, I'll give him a bond. It'll be $3,500. Sir,
you.
sir, you
Le
have a
voy-
good lawyer. Listen to what he tells you. Thank you.
Señor, le establezco fianza de $3,500. Señor, usted tiene un buen abogado. Hágale caso a lo que él le diga.
Anything else? Thank you, sir. All right,
Gracias,
next we
señor.
have out-of-turn cases for corrections. First one will be Leroy Pierre on page 6. Good morning, Mr. Pierre. You were arrested for possession of cocaine and petty theft. I will appoint the public defender's office for you. So, sir, you, let's see.
Corrections, he's a fugitive.
Broward with a $2,500 bond.
There's probable cause for, let's see.
And Your Honor, he has a fugitive hold from Broward for $2,500.
There's probable cause for the charge of possession of cocaine and petty theft. You are ordered to stay away from the Home Depot store at 12055 Biscayne Boulevard in North Miami, Florida. You are not allowed to go to that store and you must stay away from there, sir. Do you understand?
Yes, ma'am.
Count one, possession of cocaine will be $1,500. Count two, petty theft is $150. Have a good day.
So good morning once again, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. We'll stay in Florida. We'll head to the other side of it and say good morning to Judge Mercer.
Sir, good morning. You're here for first appearance. You're accused of 3 new charges. You're accused of 1 count of aggravated battery with a deadly weapon on a law enforcement officer, 1 count of resisting an officer with violence, and 1 count of introduction of contraband into a state correctional facility. I've read the complaint, and there is probable cause for all 3 charges. I've also looked at your criminal history, sir, and I think you're entitled to a bond. I want to listen to the attorneys before I address the bond status. Mr. McDaniel?
Nothing, Your Honor.
Mr. Mitchell?
Nothing right now, Your Honor.
Mr. Figueredo, I'm going to set your bond at $50,000 on the aggravated battery charge, $10,000 each on the other 2 charges, sir. Your total bond is a total of $70,000 cash or surety, and you do have a condition of no contact with the alleged victim. Do you have any questions, sir?
No, sir.
All right, sir. Wish you the best. Corporal, we have 1 person that has friends or family in the courtroom, so let me take that case next. Actually, we have Mr. Friedman. So let me take this case. We want to see what Mr. Friedman has. The next case we have is Dustin Brady. Mr. Friedman, are you here on that case or a different one?
No, you're excuse me, Your Honor. I'm here on Shantika Humor.
I couldn't hear you, Mr. Friedman. Which case are you here on?
Shantika Humor with an E. Her last name starts with an E.
Okay, I'll call that case next. Mr. Brady, you're already up there. Mr. Brady, you're here for first appearance. Mr. Brady, you're accused of 1 count of armed robbery. Your mother is in the courtroom, sir. You're here for first appearance for that charge. I've read the complaint in your case, and I think I'm the judge that actually set the bond in your case. Mr. Brady, you're already out on bond in 25-77 CF. So let me listen to the attorneys, and I'm going to address your bond status in your new case. Mr. McDaniel.
I don't have anything.
Thank you. Mr. Mitchell.
Nothing, Your Honor.
The state asking his bond be revoked in 25-77.
Yes, Your Honor.
So, Mr. Brady, I'm going to set you bond in a new case. That bond is going to be based upon the fact that you already have a charge pending that you're out on bond and the allegations against you in the new case. So for that degree crime, armed robbery is a 2nd-degree felony, but it's with a firearm as the allegation. So your bond's going to be $50,000, Mr. Brady. Mr. Brady, I'm going to revoke your bond at 25-77, at least until you see Judge Garcia. When you get over to circuit court, sir, she may elect to reinstate that bond. That'll be her call. But right now, even though you've got a bond in the new case, don't try to post it, Mr. Brady, because you won't get out anyway, because I'm revoking the bond in the case you already had pending. Let me see if there's a condition of random urinalysis in that case. If it's a drug offense, there probably is, but I don't think it was a drug offense. I think it was a uttering or something like that.
It was, Your Honor. It wasn't a drug offense.
Okay, so I have no reason to drug test you unless the judge made a condition at your original bond, and that's pretty unusual on an uttering. Let's just double check and make sure. 25-77 CF. There it is right there. So, Mr. Brady, what's going to happen, sir, is I'm going to ask Mr. Mitchell to get me an order revoking your bond in 25-77, and will also notify your attorney in that case. Looks like he was appointed regional conflict counsel, Mr. McDaniel. So y'all can let him know that he's in jail with no bond. Hopefully that email to them will trigger them to come and see you at the jail. So you'll be seeing the attorney in that case, and then we'll see what happens if the public defender's office has a conflict in the new case or not. And Mr. Brady, I don't see any condition of random urinalysis on your first appearance. So I can't, in good faith, require a drug test. Mr. Brady, do you have any questions?
How do we get this out of the way? That's what I want to know. Because, I mean, what they're saying happened didn't happen, and I don't know how there's probable cause if it didn't happen. So.
Yeah, and probable cause doesn't mean you're guilty. Probable cause means there's some evidence there that could lead a reasonable person to believe you may have committed the crime you're accused of. So it's a pretty low burden. The problem is you are already on bond. So my suggestion is you just need to talk to an attorney in private. That's what you need to do. Don't talk about the allegations against you on a recording. Any other questions?
No, sir.
Ma'am, in the courtroom, do you have any questions? All right. So, ma'am, you may want to contact the regional conflict office. Their office, as a matter of fact, is right behind the courthouse. So if you swing by there and give them your name and number, they can probably give you a little information. Now, they've just been appointed pretty recently, so it's, they're pretty new. Only if the public defender's office has a conflict in the new case, and I have no idea. So it has to go through the public defender's office first, and if they have a conflict, then he would get a regional conflict counsel in both cases, most likely. if the second, her question, I don't know if you can hear, your mother's question is if the new charge is dropped, could the bond be reinstated? And the answer to that question is yes, it's possible. That would be the decision made. If it's dropped and the law and state attorney's office says we now believe this didn't happen, then it's very likely to be reinstated. But ultimately, that'll be a decision for Judge Garcia to make. Okay. All right. Wish you the best, Mr. Brady. Thank you for coming, ma'am.
Thank you, Your Honor. Love you, Mom.
Mr. Friedman, thank you, ma'am. Mr. Friedman is here on behalf of Shantika, and I may be mispronouncing this name. I believe it's Humor.
Believe so.
Ma'am, good morning. And ma'am,
Good
how do you say
morning.
your last name?
Humor.
Ms. Humor, you're here because you've been accused of one count of unlawful compensation or reward for official behavior. Mr. Friedman is here on your behalf. Mr. Friedman, when I looked at the case this morning, it's really unusual. Let me open the file back up. 25-3. Mr. Friedman, the question I have, and you may not know, since I know that you weren't involved in the case originally, the allegations are this occurred, this unlawful compensation. There is probable cause, but the question I have is the allegations are this occurred between October and December of 2022. And the complaint wasn't signed by law enforcement until July of 25. So which means the state attorney's office didn't get it until after July of 25. So Mr. Mitchell, is there any reason you know why there would be that excessive delay in the complaint process?
I have not received any information at this moment.
Okay. Mr. Freeman, any information you have on that or anything else you think I need to be aware of?
Yes, sir. Briefly, I spoke with Ms. Jeffcoat about this. This is one of those cases. It looks like it sat on the desk of somebody for a few years. Same when I was before Your Honor about two weeks ago on the other case that involved the Department of Corrections, where also 2 years later the warrant was active. Same thing happened here. It seems like once my client found out about the warrant, we made plans to turn herself in so she's not trying to flee. I don't know what the police report says, but I talked to Ms. Jeffcoat. Doesn't seem, even though it is a felony, as serious as things could be. So we're hoping to just have her released and she did turn herself in. And so she go about her job, and I'll file the notices and we'll go forward from there. But that's why it just sat on somebody's desk apparently, and then they left and it all got turned over. So there's a series of filings of different cases like this.
Thank you, Mr. Friedman. Mr. Mitchell, anything else?
No, Your Honor.
So, Ms. Humor, I don't normally offer a conditional release in a charge like this particular charge, but I usually don't see
Yes, sir.
cases that sit on somebody's desk for 3 years. It appears that's something happened to cause a delay. And the problem is it makes it very hard for you to defend yourself, makes it more difficult for you to defend yourself now. And so I understand there's constitutional issues there. What I'm going to do is let you pick between a bond and a conditional release. If you'd like to post a bond, I'm going to set you the normal third-degree felony bond, which is $5,000 cash or surety. I am going to offer you a conditional release due to the extreme delay between the allegations of the alleged crime and the crime being discovered. And then 3 years later, almost 3 years, of the filing of a complaint. Do you understand what a conditional release is, or do you want me to explain it to you, ma'am?
I don't know what that means.
So there's two ways you get out of jail. The first is a bond. The way the bond works is you can either put up all $5,000 and be released, or you can go through a bondsman, and the amount the bondsman charges you is negotiable between you and the bondsman. Usually it's around 10% of the bond. So if you go through a bondsman and the bondsman charges you 10%, it would cost you $500 to get out of jail. The only conditions of the bond would be don't be charged with any new crimes, don't miss any court dates, and have no contact with the Florida Department of Corrections. That's how a bond works. In your situation, not everyone's offered a conditional release, but I'm offering you a conditional release. And here's the difference. On a conditional release, you don't put up any money to get out of jail. It's a pretrial release program is what it is. So what that means is you have more rules than a bond has, but it doesn't cost you any money up front. So you just get out of jail because of your history. You have the same rules as a bond plus other rules. So you would have those same rules, plus you would have a rule that you report into a probation officer once a week. That's by telephone, not in person. You could be drug tested at any point. You can't possess or consume alcohol. And then you've got the same rules the bond has in addition to those. So if you prefer the conditional release, it's usually cheaper than a bond. Now, conditional release is not free. In Jackson County, conditional release is $30 a month. You may be on release 1 or 2 months. You may be on release several months, depending on how long it takes to get the case worked out. But a bond usually costs more. But under a conditional release, you're under court supervision. So you have more rules to follow. Do you have any questions, ma'am?
No, sir.
Do you want to talk to Mr. Friedman before you make that final decision, ma'am?
Yes, sir.
Okay, so what I'm going to do is Corporal, I'm going to ask that she talk to Mr. Friedman by telephone. And then once she does that, she'll let you know whether she wants the bond or the conditional release. And if you accept the conditional release, we'll see you at the courthouse when the jail brings you to be instructed by the conditional release officer. If you decide to go with a bond, ma'am, then you'll get to use the phone after first appearance to try to post the bond. Okay?
Yes, sir.
Mr. Friedman, anything else?
No, Your Honor, just for the record, so she has it. My phone number is 850.
I should have said that
It's
earlier.
the office number. Yeah, it's the office number. I'm
You
not
may not
worried
have a
about
problem
it.
with it then if it's office
Yeah.
number. So Corporal,
Yeah.
if you could take this number down, please, for Mr. Friedman,
Yes, sir.
and give it to her, please.
Go ahead.
850.
Thank you,
I got
Mr.
it.
Friedman. So, man, we'll see you at the jail at the courthouse if you accept the conditional release, and if you accept the bond option, you'll get to use the phone. You get to use the phone either way, but if you accept the bond,
Yes,
you'll use the phone in just a few minutes. So, Mr. Friedman, anything else today?
No, Your Honor. Thank you, sir.
Thank you, sir. Have a good day.
You too.
So as far as friends or family in the courtroom and attorneys go, that's everyone. Let me move on to the next case on the list, which is Ricky Rolak. Mr. Rolak, good morning. Mr. Rolak, you're here because you've been accused of, you have a warrant out of Washington County, Mr. Rolak. I've got a copy in front of me. I've got a couple of felony charges over there. Sale of methamphetamine 1,000 feet of a specified area and a unlawful use of a two-way communication device. Mr. Rolak, the warrant that's signed by Judge Peel does not have a bond on it. Now, that doesn't mean that you're not going to get a bond. What it means is you won't get one until you get there. You'll go to Washington County, Mr. Rolak. When you get there, you'll go to first appearance in front of the local judge. That judge will, and if they have a bond schedule, I don't think Washington County has a bond schedule, but they'll review your status and they'll set you a bond if you're entitled to one, but you won't have a bond until you get there. I try to tell people when they're going to go. I don't know exactly. Washington County is right next door to us, so it could even be today, but more than likely you're going to be in Washington County in the next couple of working days. You have any questions?
Yes.
All right. Wish you the best, sir. Kevin Tipton. Mr. Tipton, good morning. Mr. Tipton, looks like you were first appeared and set a bond on a new charge, but held for 7 days to see if the probation office was able to secure a warrant. And I've got a no bond violation of probation warrant, Mr. Tipton, that I saw. So what I want to do this morning is go ahead and get you arraigned on that. Judge Garcia signed a no bond warrant for violation of probation. Would you like an attorney appointed to represent you in that case?
Yes, sir.
I'm going to appoint the public defender's officer of the 14th Circuit to represent you, Mr. Tipton. Listen to Mr. McDaniel, and I'll see if you have any questions in just a moment.
Your Honor, we're going to plead not guilty. Asked to set this on the September 4th pretrial docket, and I advise you, Mr. Green, will come by and visit him prior to that hearing.
Thank you. Mr. Mitchell, anything?
No, Your Honor.
So, Mr. Tipton, your attorney will see you before your court date. Do you have any questions?
Yes, sir.
All right, thank you. Have a good day.
So real quick, Charles just asked, what is unauthorized use of a two-way communication device? Specifically, what the hell is it? Just looked it up in Florida. Unlawful use of a two-way communications device is a third-degree felony when used to facilitate or further the commission of any felony offense. This means that if you use a device like a cell phone to help commit a crime, you could face up to 5 years in prison, 5 years probation, and a $5,000 fine. So I would liken it to like the concept of mail fraud, where if you mail something in the commission of a crime, that's mail fraud, and it's just an extra charge that has teeth to it. This seems like a similar thing.
Yes, sir.
Have a good day, sir. Kristen Floyd. Ms. Floyd, good morning. Ms. Floyd, you were added on today because you had a violation of conditional release that you've been in jail several weeks for, and I believe they've reached a resolution in your felony case. Is that right, Mr. Mitchell?
She has a PTI offer in there. I don't know if
They
she's
pled
official.
yesterday, so.
She did plead
Yeah,
yesterday?
it's over with.
Oh, okay.
So has she accepted the PTI, Corporal? Ms. Floyd, did you accept the PTI? Have you signed everything yet, or just?
Yes, sir, I did.
Okay. So I'm not taking any further action on the violation of pretrial release. You've been in jail several weeks, ma'am. And that, I think that's more than sufficient to address any allegations of contempt. So I won't be taking any further action. So you're going to be released, ma'am, on the violation of conditional release charge. Just comply with whatever the officer told you. Were you given instructions about reporting with them, or have you already done that?
No, sir, I'm going as soon as I leave here.
You'll be released this morning. Any questions?
No, sir, thank you so much.
Yes, ma'am. Wish you the best.
Thank you.
Yes, ma'am. And Corporal, I believe that takes care of first appearances as far as in custody. Anything else from the jail?
No, Your Honor, that was it.
Mr. Mitchell from the state, as
Nothing
far as the
from the
jail goes?
Yeah. nothing
Mr.
from the state.
McDaniel?
Nothing, Your Honor.
Corporal, do you have anybody else waiting to use this Zoom connection, this room?
No, sir, not that I know of.
Okay. We have one case in the courtroom we're going to take care of and just stay on the same recording, and that's Mr. Adan, Alexander Adan. Mr. Adan, come on up, please. This is State versus Alexander Adan, case 25-86 CT. Mr. Adan is accused of violating the terms of his probation. So, Mr. Adan, Mr. Goodson has filed an affidavit, but it's a really unusual case. So I want to ask Mr. Goodson to put on the record the status, and then we'll see what the state and defense's position is.
Yes, sir. Thank you. Judge, Mr. Dan was put on probation on, looking at the wrong paperwork, March 3rd of 26. He has been in compliance. He has checked in on a monthly basis, little behind on his fines, but he has paid some towards his court costs. He is up to date on his probation fee. I received a call yesterday from the representative from Chrome, informing me that Mr. Adan had went on his own to Chrome and I guess filled out the application and the orientation to try to get into the Chrome inpatient drug treatment facility. It was reported to me by the representative that he was accepted into the program. I received a letter. I gave it to you this morning. I told the representative that I would need to see Mr. Adan prior to him going to the program. He showed up yesterday afternoon in my office with his pastor. We discussed certain things. Mr. Adan did admit to me of possibly having a drug problem, but he did admit to me of using Molly. So I filed an affidavit yesterday afternoon. I instructed Mr. Adan along with his pastor to be here this morning at 8 o'clock. Mr. Adan was here at 8 o'clock and reported. I'd spoken to you this morning and you instructed me to have Mr. Adan to appear this morning in front of you. And that's kind of where we are.
Thank you. So, Mr. Adan, my understanding is that you have sought out help to get help with the drug treatment, drug addiction. And at the time you did that, you were in good standing on probation. To me, that's totally different than someone that fails a drug test and then all of a sudden they won't help. So your case is unusual. I don't see this kind of case very often. What I'm going to do is I'm going to appoint the public defender's office to represent you. I'm going to tell you you're accused of violating the terms of your probation. Listen to Mr. McDaniel, because I think there may be an agreement reached to accomplish what you wanted to accomplish to begin with. So listen to Mr. McDaniel, please.
Your Honor, at this point in time, I spoke to Mr. Adan. We're going to admit that we violated the probation with the understanding that it's going to place him back on probation with additional conditions that he continue to attend Chrome, waive any cost of supervision, that the fines that are owed in the case, which I believe are $300, can be worked off by his at Chrome facility by doing public service work, and that'll resolve the case today.
Did you say enter and successfully complete? You may have said that.
I don't know if he was successfully completed. I think it's either 6 or 9 months. I think he got like 6 more months of probation, but at least
for the amount of time. At least for the amount of time he's got on probation.
Correct. At least for the remainder of his probation that he's not leaving Chrome.
So I got the condition that you will agree to enter and complete the Chrome inpatient treatment program and comply with all said rules of facility. That's normally what we do.
And what is the date he would complete his probation? Because they changed that program recently from a 6-month to a 9-month program.
He will actually terminate his probation on March 3rd of 26.
So you would at least have to be there until then.
Okay.
You understand that?
Yes, sir.
Any questions about any of that?
No, sir.
And the difference is it's going to be court ordered now, whereas yesterday you were going to try to go voluntarily. So I have no problem with you doing this. I think it's great. If you think you need help, you'd get it, but you've got to stay and complete it.
Oh, I'm going to stay.
Okay. And you know what happens if you don't stay? If you violate probation in a substantial way, you know what happens?
Yes, sir.
What?
I have a warrant for my arrest.
Okay. Yeah, I don't want that to happen. You don't either.
No,
So,
no, sir.
but having said that, I appreciate you dealing with the problem prospectively, you're dealing with it up front. So I can count on one hand the number of times I've had this happen. It's very rare. Most people don't want to deal with the problem until they get in a bind. So I appreciate that. Mr. Mitchell, is all that agreeable with the state?
It is, Your Honor.
And I see that you've got Reverend Petty with you today. Reverend Petty, anything that you want to add, Pastor?
No, sir.
You feel like this is the program for him? Okay. All right, this is what you want to do, Mr. Dan, right? Is this what you want to do?
Yes, sir.
I'm going to accept your admission that you violated the terms of your probation in case 25-86 CT. Mr. Dan, I'm going to find that admissions freely and voluntarily enter with the advice of counsel. I'm going to modify the probation to add a condition that you enter and successfully complete at least through the date of your termination of your probation, the inpatient drug treatment program at Courtroom. So you'll go in the program, you'll stay, you complete the program, and that will satisfy your probation. Also, what I always do is if they make you do community service or they allow you to do community service, that will count towards your court costs and fines. And the reason that's good is when you get through, you won't have a bunch of money that you owe. Okay. So now if you don't stay, there's consequences, but I want you to stay and complete the program. Mr. Goodson's going to get you instructed. Make sure you don't have any questions, and then they're going to get you out of here. Is your plan to go today to the program?
Yeah, he was going to.
Pastor Petty's going to take you today. Mr. Goodson?
So I did an amended probation order, so I shouldn't have done that at this point. So my understanding is he's admitting, and the actual revocation will be that he's continuing on probation with an additional condition of complying with inpatient treatment. There was a warrant issued, so Mr. Applewhite, since he admitted.
There's a warrant signed.
Yes, sir.
I don't think it's been.
It's probably been sent to the sheriff's department.
It has been already?
Yeah, I would imagine Tiffany, yes, so she
Was it filed
sent it this morning.
Okay.
So if he's admitting, can Mr. Applewhite serve this warrant on him?
Yeah, that's no problem. So the warrant's already in the system. So we got to get the warrant served so it's out of the system. And it's not a revocation, it's a modification. So on his paperwork, his probation's been modified, not revoked.
Okay.
Okay. So Sergeant Applewhite's going to serve you in just a second and get your fingerprints. That way we get the warrant out of the system. I don't want you to get arrested 6 months from now on an old warrant.
Okay.
So that we got to get that warrant out of the system. You don't have to go to jail. Just got to get the warrant out of the system.
Okay.
Okay. Any questions?
No, sir.
All right. I'm going to ask you to see Sergeant Applewhite over here by the fingerprint machine, and he'll take care of that. And then they'll let you see Mr. Goodson in just a minute. Okay.
Okay.
Wish you the best, sir.
Thank you.
Okay.
So you can let me know in the chat if you think differently, but generally I really like Judge Mercer and how his court runs and how that all works. You know, they identified a potential issue with the warrant, so they're going to clear that out so he doesn't have future issues. There's a pastor involved to help this guy out, so a lot of community involvement. I generally get good vibes from that court. Let's go to Texas. We'll say good morning to Judge Stevens.
Sorry, I know you were on top of that.
Okay, are you aware of this? He filed a motion.
He just told me that.
Sir?
He just told me that.
5 years. Day before yesterday. All right, anything you want to summarize on this, Mr. Dewsbury?
No, sir, other than what I've already got in there, I think he agrees to everything.
Are you able to hire a lawyer?
I've been working on it, but I just haven't been able to because of my student situation.
About your what?
My student situation.
What about it?
I'm just doing school right now, so I haven't been able to do it.
I paid my way through school. College, doctorate, master's degree. I paid my way. I worked and paid. Yeah, I mean, if I can do it, I'm not special.
I'm working.
You can do it.
Yes, sir. I am working on it.
Well, the taxpayers are paying this.
Yes, sir.
And they don't find it amusing to be paying for indictments from other people. It's not a free ride. I mean, it's just you're accused of a crime and you got to fix it, and everybody's got to figure it out on their own on how that's done in a responsible way. Well, problem you have here is were you retained or okay? See, I'm not going to put my public defenders in a situation where they feel like they are threatened. You can represent yourself. Well, that's what he says.
No, I just asked for the.
What happened, sir? Can you summarize?
Well, on the most recent event last week, he and his father showed up in my office.
Him?
Yes, very demanding, threatening my staff.
In what way did they threaten your staff?
With expletives. And
You're cursing?
no, I didn't.
What, he's making this up,
I promise
sir?
I didn't cuss, sir.
He's making this up?
I barely said anything when I got there. I didn't make it. I didn't.
Did he? Was he cursing?
Primarily the father.
The father was? You know, oh, wait a second, sir. I've known this man for 40 years. You know, when I speak, you be quiet.
Yes, sir.
Because two people can't speak over each other.
Yes.
She's got to take everything. All right. So you've got something on video?
Yes,
I
sir.
want to see that.
Can I come? May I approach? Sir?
Yeah. Yeah, because this is, yeah.
The
you know,
whole interaction.
all right, good. Well, this is, a problem, and
There we
public defenders aren't
Your Honor,
going to.
Mr. Dues.
Hold on, I'm speaking. The public defenders aren't going to be put in harm's way,
No,
especially.
sir.
Hold on. I'm going to point to you when we get to speak, okay? Because that's the way it's going to work, because you keep interrupting. The public defenders, the people who are paid by the people, I mean, he's not getting paid extra. He's not getting paid retained attorney's fees, like some lawyers who charge a lot of money, because we're talking about a first-degree felony, life imprisonment. So what's that worth? You know, it's worth people paying money for help to get them, help them out in their situation. But it doesn't do anybody any good who needs the help, unless you want to represent yourself, which is always catastrophic. To threaten the people who are there as your lifeline. And these are appointed, the taxpayers are paying him and my other public defenders for people who are unable to pay, which I find a little odd, since I worked the day I turned 16. I've worked from the day I turned 16. I've worked my whole life. From the day I turned 80 cents an hour at 3 a.m. If I can do it, anybody can do it. It's just a matter of having the will and the effort. But when you are charged with a crime, you've got some responsibility of helping yourself see through this. All right. Let me look at this here.
Yeah, so Judge is muted here as he is listening to this recording, and it doesn't surprise me that he chose to mute, just simply because of the fact that if this is a recording from the lawyer, then there's probably some attorney-client stuff. But we are on the Wayback Machine a little bit, so let me try to nudge us forward a little. Oh, come on, you're done listening. Oh, Judgy. He never unmuted, folks, so I have no idea how that all ended. That is disfortunate, as they say. Oh well, what are you gonna do? Let's since I got to figure out when he hits the unmute button so we can get back to him at some point. Let's go back to Florida, but Judge Brantley Clark, Bay
The
County.
state is that his probation would be revoked. He'd be assessed $100 cost of prosecution fee. Any unpaid monetary obligations be reduced to civil judgment. He'd be ordered into Lifeline. He would be sentenced to 365 days in the Bay County Jail with release upon successful completion of Lifeline.
That's the agreement with the state? He was already adjudicated guilty.
Yes, sir.
Is that correct?
Yes, sir.
Yes, sir.
You can put your hand down, Mr. Petty, and state your name.
Ashton Petty.
Mr. Petty, you heard the announcement of Mr. Gunner, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your violation report with Mr. Gunner?
Yes, sir.
Have you had sufficient time to speak with Mr. Gunner about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
Waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses that you might have to these allegations?
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir.
You're waiving your right to testify and remain silent at the evidentiary hearing, which would be your decision to make?
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence?
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Petty, do you feel the admissions in your best interest?
Yes, sir.
Do you agree that you violated the terms and conditions of your probation by several things, but the most important things was failing to report and absconding from supervision?
Yes, sir.
I'm gonna find there's a basis for the admission. I'm gonna find that Mr. Petty's admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. His probation is revoked. He is sentenced to 365 days in the Bay County Jail. He waives credit for time served for this sentence only. He'll enter and successfully complete the Lifeline program. Once he completes that Lifeline program, that will satisfy his jail sentence, and he'll be released from custody. All monies that were previously imposed and have not been paid are reduced to a civil judgment. There's an additional $100 imposed today for the cost of the prosecution of the violation of probation. That's also reduced to a civil judgment. Mr. Petty, you have 30 days to file notice of appeal if you wish to appeal your judgment sentence. If you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir.
That's all I had this morning, Your Honor. Thank you.
Good day.
You too.
Mr. Meredith?
Is Julius Cohn standing in for somebody from Division C?
You don't know anything about it?
I didn't get any wild police.
I mean, we don't have to go for.
I'll stand in and handle this one.
I mean, I don't care. I mean, if they hadn't done what they're supposed to do, it doesn't.
I'll handle it. They said there was one yesterday and I asked for it. It was on the docket, so.
That's fine, Judge. My office that I can.
Okay. I can't tell who the public defender or state attorney is on the.
I think it may have been Miss Crook.
It's Judge Stevenson's case.
I'll figure it out.
Yeah, I think it was Miss Crook that from ours.
I tell them I don't, it won't hurt my feelings at all to send them all back to them, but we get y'all ready to go forward, I'll go forward.
Okay. Judge, this is Julius Cohn, case 24-4015. He's prepared to admit having willfully violated terms of his supervision with the understanding it'd be revoked. He would be sentenced to 1 year in the Bay County Jail, waive credit for this sentence only. He'd enroll and complete the Lifeline program. He would be released upon successful completion of Lifeline. There's $250 cost of prosecution for today's proceedings. That and any unpaid monetary obligations would all be reduced to a civil judgment.
I guess we're gonna have to assume that he's been approved for the Lifeline program, don't we?
Have you been screened for it?
Yes, sir. I've been in Lifeline for already 2 months.
Okay. You know what happens when we assume, but we'll go ahead and assume.
Derek, is he in there? No, is he in there with you guys? Judge, it's confirmed.
Okay.
That's as probably as good a confirmation as we could hope for. I'll accept it. All right, if you'll swear, Mr. Cone, in.
solemnly swear the testimony you're about to give is the truth, the whole truth, and but the truth, so help you God.
Yes, ma'am.
All right, Mr. Cone, you lower your hand and state your name.
Julius Cone.
Mr. Cone, you heard the announcement of Mr. Meredith, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol today which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read this agreement?
Yes, sir.
Now, have you had a chance to go over it? And who is your attorney?
Sarah Crook.
Did you have a chance to go over this with Ms. Crook?
Yes, sir. Yes, sir. I have.
You understand what's going on?
Yes, sir.
You need to talk to Mr.
No,
Meredith
sir.
or Ms. Crook anymore.
No, sir.
Are you ready to go forward with this plea?
Yes, sir.
All right, do you understand that you're waiving your right to have an evidentiary hearing in this?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses you may have to these allegations?
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Let's see, Mr. Cone, do you agree you violated your probation by failing to failing to report, or having a positive drug screen and by changing your residence without permission?
Yes, sir.
I find there's a basis for the admission. I'm going to find that Mr. Cone's admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. His probation is it revoked? It's revoked. He is sentenced to 1 year in the county jail, waives credit for all time served for this sentence only. He will enroll and complete the Lifeline program. Once he completes that Lifeline program, that will satisfy his sentence. He'll be released from custody. All monies previously imposed and not paid are reduced to a civil judgment. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. That's also reduced to a civil judgment. Mr. Cone, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you, and you can't afford one may be appointed to represent you at no charge. Good luck to you, sir.
Yes, sir. One more thing. I had an attorney visit like a week ago, and I have a misdemeanor, resisting arrest, and she said bring it up in court, and then y'all would time serve me and handle it here.
She's gonna have to get somebody to get you a plea and abstention. So what I'll do is ask Mr. Meredith to contact Ms. Crook and get that to you. Okay.
Yes, yes, sir.
Your Honor, on Zoom is Mr. Vernon.
All right.
And Judge, we got quite a bit of information. I believe it was yesterday. It may have been sent to my old assistant, but it got to me yesterday about they're behind.
What is that sound?
He's on his work site.
Oh, okay. All right. That like something else.
He's been trying to make payments on the restitution, but there was a question about whether several years ago there was a $500 a month agreement when Mr. Kelly represented him. He has a good job, but he hasn't been able to make those payments, but he's trying to make the payments. He is keeping in touch with us. I do want, his wife was concerned that we hadn't talked to him about updating the amount due. So if we could just continue this on with Mr. Sullivan's permission, let him keep trying to make payments.
You want to put it on a status conference or just let it go? I mean, we reviewed it every couple of months. There shouldn't be any more questions about.
I know it's a lot, but if we could do a civil judgment, and, I mean, he is working every day. He did lose, he was in danger of losing his housing, and, a couple of his utilities were turned off over this summer. And he will never darken Bay County's,
Judge, we can set it for next month and let me,
How many cases does he have?
to your honor, 164437 17848.
Judge, because he no longer has any time, he's not actually being supervised. He's just making the payments.
Okay, no, that makes sense. Okay. All right. Well, let's set it for next month, let Mr. Sullivan make a decision as far as the award tennis motion that Mr. Meredith just made to reduce everything to a civil judgment. We'll set it for the September. What date is that, Madam Clerk?
September 17th.
17th at 9 o'clock preliminary.
Brad, did you hear that?
What day? 17th?
It's
What month? I'm sorry.
September, just next month.
Okay, I got you.
All right, and if you want to talk with me, get a hold of me soon. My time's going fast.
All right, I got you. I'll get a hold of you soon.
All right, sounds good. Thank you.
Thanks.
I continue or let Mr. Salim.
Let's let Mr. Salim, you want to go ahead and call your case?
Yes, Your Honor. I just have one. It's State of Florida versus Dario Batiste, Batiste.
He's not out yet.
Okay. Thank you, Your Honor. I will be here. Thank you, Judge.
Mr. Koo?
No, don't worry about that baby. Dude, that baby, he's the only one that can whine in here. I hear enough whining from everybody else. I let that baby whine. That baby's not hurt. He's not, y'all stay, he's not bothering me. No, don't be. We ain't had a baby since you've been in here, so don't worry about that. But I hear enough that everybody else whine. He can whine. He got a reason to whine. Oh, no, you're right. And I probably should, but I'd rather hear that than a bunch of stuff I have to hear. Yeah. Or from out here too. Go ahead, Mr. Meredith.
Judge, Mr. Koo is before you, and it's now misdemeanor case 25-3661. He would enter a plea in absentia to that. Based on that plea to the misdemeanor, he would acknowledge having willfully violated the terms of his supervision with the understanding that it'd be modified. His probation would be extended to 36 months from the original supervision start date. He would undergo intensive outpatient drug treatment. The balance of his supervision would be on drug offender probation, and he could substitute NA meetings for his community service work hours. There's additional $250 costs of prosecution for today's proceedings, and all prior conditions are reimposed to the extent they remain incomplete or modified by this sentence.
That's the agreement with the state.
Always swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yeah. All right, sir, you can lower your hand, state your name. Hey, cool. Mr. Koo, you heard the announcement of Mr. Meredith. Is that correct?
Yes.
Is that your understanding of the agreement with the state?
Yes.
Has anybody promised you anything different?
Yes.
You can put your hand down. Has anybody promised you anything different than what Mr. Meredith just said? They have? You just heard what Mr. Meredith said. Is that correct?
Yes.
Has anybody promised you anything other than what he just announced? Listen to my question. Did you hear what Mr. Meredith just said?
Yeah, I do well.
Yep. Has anybody promised you anything different from that?
I understand that.
You speak up to the microphone.
Yeah, I understand that.
You understand that nobody's told you anything would happen any different from what Mr. Meredith just said. Is that correct?
Yes.
Okay. And you're not under the influence of any drugs or alcohol today, which would impair your ability. Is that correct?
Yes, I do.
Do you understand what's happening?
Yeah.
What's happening?
Oh, no alcohol, no, nothing.
No alcohol, no drugs?
Yeah.
All right. And you're going to have to go to treatment. You understand that?
Yes.
You understand you're waiving your right to have an evidentiary hearing?
Yes.
You're waiving your right to require the state prove the allegations against you?
Yes.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes.
You're waiving your right to present any defenses you may have to the allegations?
Yes.
Are you doing this because you want to?
Hello, good.
Yeah. Do you think this is in your best interest?
Yes.
All
I
right.
tell you what.
I'll accept the basis that Mr. Meredith placed on the record. I'll find there's a basis for the admission. I'll find that Mr. Koo's admission was freely and voluntarily made. After consultation with his attorney, I'm going to accept it. His probation is modified as follows. It's extended 36 months from the supervision date. As a special condition, he'll enter intensive outpatient drug treatment. The balance of his supervision will be on drug offender probation. He may substitute NA meetings for community service work hours. All other conditions that were imposed or reimposed, there's an additional $250 imposed today for the cost of the prosecution of the violation of probation. And you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you and you can't afford one may be appointed to represent you at no charge. Good luck to you, Mr. Koo. If you'll step over and speak to the probation officer.
Mr. Taylor?
Thank you, sir.
I won't graduate until 9. Put you on 9/19. The date that other guy passed my test. You're gonna pass it.
I just filled in wondering.
Uh-oh.
I'm studying.
Is 9/19 the next, is that the date? Your Honor, this is Derek Taylor in case 23-15-31 and 23-25-19. This time he's prepared to admit having willfully violated the terms of his supervision by testing positive for a controlled substance. The agreement we've reached with the state is that he would plead today, be sentenced on September 17th. That will allow him to finish Lifeline.
Any objection?
The agreement we reached with the state is that his probation be revoked. He'd be sentenced to 20 months Department of Corrections. He has 396 days credit against that sentence today. We'll update that when he comes back for sentencing. There's $250 cost of prosecution for today's proceedings. That and any unpaid monetary obligations would all be reduced to a civil judgment.
That's the agreement with the state.
Raise your right hand. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, Mr. Taylor, you can lower your hand, sir, and state your name.
Derek Austin Taylor.
Taylor, you just heard the announcement of Mr. Meredith. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature over the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your violation report with Mr. Meredith?
Yes, sir.
Have you had sufficient time to speak with Mr. Meredith about your violation?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to these allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which will be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Taylor, do you feel this admission is in your best interest?
Yes, sir.
All right. I'll accept the basis that Mr. Meredith placed on the record, and I find there's a basis for Mr. Taylor's admission. I'm going to find his admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. I'm going to set sentencing for September 17th at 9 o'clock. Good luck to you, sir.
Thank you, sir.
Okay, guys, it's a little bit of a weird morning out there in the courtrooms across the country. Barely any action in the state of Michigan today. Judge Stevens just abruptly ended his stream and deleted it. No idea why, but he did. But this gives us the opportunity to try some new things, and I've had my eye for a few weeks now on Division 12 in DeKalb County, Georgia. So let's give that a look. They're doing bond reconsideration calendar there.
All right, go ahead. And that's also my case, Judge. So the defendant is in no bond status. He was arrested on July 22nd of 2025. This incident did happen in December of 2024. So he was not arrested immediately after this incident. This incident happened in regards to officers responding to a vehicle that had been set on fire at 2092 Wilson Avenue here in DeKalb County. They extinguished the fire and a human body was found in the back seat of the vehicle. The victim was dead and burned beyond recognition. The body, it was basically wedged into the floorboard of the back of the car. Further examination revealed several gunshot wounds to the body. And the area that the vehicle was found basically was a place where people dumped trash and garbage. There were no witnesses to the car being placed there, but investigation into the car's registered owner led police to the suspect of the deceased, which was the defendant in this case, the victim in this case, Mario Culver, who was 36 years old at the time. With the help of his family as well, they were able to reach out to them and identify them through DNA that, in fact, the burned body was Mr. Mario Culver. Investigators then began to speak with friends and family about his last known whereabouts back in December. They determined that he was with a male friend in the Lakewood area, around gambling around 5 a.m. when he left to go meet with a girl that he had a history with for several years, which is going to be one of the eyewitnesses in this case. That friend told the police that Mario told him about the girl's issues with another man, that would be the defendant, and showed him a video from her showing inside the home and damage by the other male. Mario's friend told him not to go over to that woman's house and urged him not to go there. Mario reassured his friend that everything would be okay, basically. He didn't know the girl's name. Crime Stoppers got an anonymous tip that the victim had been shot multiple times on December 24th of 2024. At that time, a man by the name of Marcus Overstreet was basically identified as the suspect and said that he had threatened to shoot Mario at the last known address of 4450 Boulder Springs Cove. Overstreet had a violent history with a female there, later identified as Miss Nicole Mitchell. They spoke with Miss Mitchell, who initially denied knowing anything about Mario's murder. She stated that she lived at the residence and she had known Mario, or he went by Rio, since she was about 15 years old. They dated on and off throughout the years. She stated that she last saw Mario when he came over to her home in the early morning hours of December 22nd of 2024. He got there around 2:30 or 3 a.m., according to her, and he was only there for about 15 minutes. Police basically got phone records that showed that she was lying, and then they confronted her with that. And they also learned that she had a history of domestic violence at the hands of Mr. Overstreet. They went to speak with her again, and they found out that on December 21st, the day before this, it was her birthday, and she didn't go out to celebrate because she had visible injuries that Mr. Overstreet had given her. On December 22nd, the victim offered to come over, and when he was done playing cards and gambling, and she wanted to talk to him because they were friends. He'd always been supportive. She says that she went upstairs to put her 1-year-old daughter down. And Mario was there. She told him to come on inside. Then she heard 2 loud bangs and multiple gunshots, and she heard Mario say, "Oh shit." And then she heard a groaning noise. She stayed in her daughter's room, and the defendant came up the stairs with a gun, accusing her of planning to have sex with Mario while their daughter was there. The defendant had a gun pointed at her with the kids present. Her 14-year-old daughter was who has Down syndromes, was pleading with the defendant to stop because he was scaring her. The defendant threatened to kill Mitchell and her family while she pleaded with him to stop and to calm down. Mitchell asked to go downstairs to check on her sons who were sleeping, which that would have been the same floor where Mario was killed. She saw that her kids were in their rooms. Then the defendant came back and placed a gun inside of her mouth, and asked her if he should kill her, which she pleaded with him not to kill her. The defendant said that he was going to take Mario's body somewhere. She pleaded with him to leave it there. She even offered to make up a story to the police about how he got shot, and he refused. And she said that he took his body somewhere. He wouldn't let her check on Mario to render aid. She said that he picked up shell casings and grabbed Mario's keys from his pocket, and she did not know where he went. She said that she was concerned that the defendant would harm her or her kids if she spoke to the police, and she was scared of retaliation, given their history of domestic violence. Her account and the statement that she gave the police is supported by other witnesses in the area, ring video in the area, social media, cell phone tower records of the victim, of the defendant's sister, who's believed to have picked him up after he dumped the victim's body and set the car on fire. There was an incident 2 months prior between the eyewitness, Miss Mitchell, and the defendant, in which the defendant threatened Miss Mitchell with a gun at that same address. It was reported that he entered the home without permission, pulled down the ring cameras, and confronted her, threatening to beat her up, and basically just refusing to leave. So, Judge, they have multiple incidents. There was another one just a month before the shooting where he grabbed her by the neck. She is not only a victim in this case, but also an eyewitness. So the state is concerned about the risk of intimidation as well as her safety were he to be released. And in terms of his criminal history, Judge, he has 25 cycles here in Georgia, 7 felony convictions, 4 probation violations, 1 parole violation, 3 FTAs, 1 fugitive from justice extradition warrant from Pennsylvania in 2021. He has multiple cycles from New Jersey and Pennsylvania. So he is a significant flight risk. I can go through all of the.
It's not necessary.
He has a pending murder out of Fulton County, Judge, right now.
All right, Attorney.
The family, we were asked, sorry, Judge, we'll ask for no bond, and the family would like to address the court at the appropriate time.
All right, you did make me aware of that at calendar call. You can sound for a member of the family.
Mr. Culver, are you on? If so, can you please, okay, but I see Mr. John Culver. Can you please raise your right hand? Do you swear and affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth?
Yes, I will.
Can you please state and spell your first name for the record? And you can lower your hand.
John Culver, Johnculver.
And can you please tell the judge your position on bond?
First of all, good morning, Your Honor.
Good morning.
I want to deny that bond because of the way he did my son. He's my only son. He took away, he had 3 kids. 3 granddaughters, and I want to deny the bond. I mean, it took 9 months, 7 months to get him, but I did not deny that bond.
Thank you.
Thank you. Thank you, and I'm very sorry for your loss. Any questions, Mr. Mack? All right, thank you. All right, we can mute Mr. Culver, and I'll hear from you, Attorney Mack.
Thank you, Judge. Mr. Overstreet is 42 years of age. He does currently live in Atlanta with his stepmother. She's owned the same residence for years. He has moved around a little bit, but that's a permanent address where he can return to. He is divorced. He does have 3 children himself, Judge. He was working security for 6 years, different locations, clubs, different bars, locations, unarmed security, Judge. I don't have much information on the Fulton County case, except the fact what I've seen in the media, Judge. So, and I don't really want to go too much in the facts of this case. It's still being investigated. I'll reach out to Miss Roberts if it's her case about some things I'm trying to get in my investigation. So I'm not even really there to argue the facts of the case like I normally would, Judge. But he is 42, lives here locally, Judge. He does have some criminal cycles, he does have some revocations. We could have some defenses to those, but at this point, Judge, we're not here for that, and I understand that. But I'd ask for Mr. Overstreet, if possible, if Your Honor could give him a $200,000 bond, as well as the same conditions of the ankle monitor, house arrest, and all the other conditions.
All right. I am going to deny bond. I do find that the defendant poses a danger to the community, that he is likely to intimidate witnesses in this case, and that he poses a flight risk. So anyone who is here on the Overstreet matter, if that is your only matter, you are excused at this time. I see Attorney Scott Fortis has come back. Attorney Fortis, are you there? Do you want to turn on your video? I called your case previously. Are you ready to proceed with position 16? Let me see, what is that? Position 16, Daylon White on the reconsideration calendar?
Yes, Your Honor, and I apologize. I'm juggling multiple courts and I had to
Okay.
go into another court, so I apologize.
Okay, all right. So we will go ahead. Let me hear briefly from Attorney Johnson, then I'll hear from Attorney Fortis as to the reconsideration.
Yes, Judge.
It's a reduction. It's a reduction, Your Honor.
Okay, all right.
Okay.
Go ahead.
Yes, Judge. For the record, the defendant's bond is currently set at $50,000 with the special conditions that he do not return to that location, have no contact with the victims, possess no guns, and to be outfitted with the ankle monitor if bond is made. The facts alleged in this case are that on January 19th of 2025, officers responded to a residence on Flat Shoals Road here in DeKalb County. There, they met with the victim, a Malaysia Wynn, who was 10 years old at the time. She left her home to speak with a courtesy officer who lives in the same building, but he was not home. They were able to speak, I guess, when she went to knock on the officer's door for help. While he wasn't there, he was able to speak to her through the Ring camera. And she told him that she was scared and feared for her mother's life. Upon hearing this, the officer did make sure that police were sent. When officers arrived on the scene, they spoke with Miss Natasha Wynn, which is the mother, and the defendant, and she reported that, Malaysia stated to police that she heard her mother and the defendant were getting into a verbal argument. Moments later, her brother, Tavius Wynn, who was 11 years old, intervened and got into a physical altercation with the defendant. Officers then spoke with Natasha, the mother, and she stated that the incident started over text messages. The defendant got angry and started punching her in the face repeatedly. She stated at that point her son, Matavius, Wynn, intervened, and that's when the defendant pulled out a handgun and pointed it at the 11-year-old Matavius for him to get away, and then the defendant fled the location. When officers arrived, they did observe Miss Natasha, the mother, did have a busted lip. She was also bleeding from her right eye. Officers were able to get that on the body-worn camera. You see the statements of Malaysia, the injuries to the victim's face, and they all state that what occurred and have similar accounts of what occurred. The defendant's criminal history is as follows. In 2006, the defendant has a conviction for aggravated assault, criminal damage to property in the second, and possession of a firearm during the commission of a felony for which the defendant pled under first offender. The defendant has a 2016 possession of marijuana with intent to distribute and obstruction of the DeKalb County conviction. In 2021, the defendant has an aggravated assault that was dismissed. However, it was involving the same victim, Ms. Natasha Wynn. In 2021, the defendant had a battery, family violence, cruelty to children in the 3rd degree, disorderly conduct, simple assault, and family violence. The defendant pled nolo only to the charge of disorderly conduct, and this involved a separate female victim who was his girlfriend at the time. At that time, the defendant has an open 2023 possession of cocaine with intent to distribute, possession of meth, and possession of marijuana here in DeKalb. The defendant has an open 2023 possession with the intent to sell marijuana and sale of Schedule 1 and 2 that's open presently in DeKalb County as well. The defendant, the state's position is that, one, there's been no change in circumstance for Your Honor to take up this matter on a bond reconsideration. And 2, the defendant still poses significant danger to the victim. They were living together at the time. The defendant has a previous violent history, both with this victim and other women, and a violent history involving the use of firearms. And once again, he caused visible injury to her. He gets the firearm and points it at her. And that's the other case, Your Honor, which also involved the firearm.
All right, Attorney.
and
Okay, so I think I understand the state's position. Let me hear from you,
Yes, Judge.
Attorney Fortis. You're muted, Attorney Fortis.
And again, Your Honor, this is not a bond reconsideration. It's a bond reduction. And we vehemently defend this case. We don't agree with all the facts in the case. I'm not going to get into that. The bottom line is the date of this incident was in January 19th of 2025. We came before the court on May the 28th of 2025, where the bond was given with the amount of $50,000 with conditions. Now, fast forward yet another about 3 months, the case remains unindicted. My client's unable to make the $50,000 bond. If the state was so concerned about this case and the facts of this case and my client and the criminal history, et cetera, then they would have, I'm sure, indicted the case. That has not been done. And so it's for those reasons that we're asking that the court reduce the bond from $50,000 to $30,000.
And Judge, if I may be heard, this case is scheduled for grand jury on September 9th, and the bond was a 90-day bond consideration, for the record.
Okay. All right. I am going to deny the motion. I do find that the bond as set is fair and reasonable given the circumstances. So anybody who is here on the white matter, you are excused at this time. Thank you. All
Thank you,
right.
Your Honor.
All right, thank you. I see multiple people in courtroom 5A. Can somebody tell me which cases the folks in courtroom 5A are here for, please?
Judge, Mr. Douglas brought it to my attention that the people who are in the courtroom are there for 2 cases I'm handling today.
All right.
One is, I believe, the mother of Mr. Cobb, position number 1. On the first calendar of the morning.
Okay.
And I believe she just is observing.
Okay.
The other people who are present are family members for position number 6, Mr. Keys.
On the same calendar?
Yes,
Yes.
Judge.
Okay.
That's right. And I apologize, Judge. I had not known that they were present, and I had not known that they apparently wished to address the court. Otherwise, I would have made that announcement at the call of the calendar. We would ask that at least one of them be allowed to address the court if possible. I apologize for the oversight, Your Honor.
All right. All right. So I'm going to go ahead at this time and hear those 2 cases. This
Your Honor, just so the court is aware, we do have position 2 is especially in a case that the victim is present as well.
All right. Well, on which case, which calendar are you talking about?
I'm sorry, Judge. It will be on the.
Are you talking about the Cody case?
The bond calendar 2.
Okay. All right. So I'm going to do 1, 6, and then 2. All right. On the regular bond calendar. All right. Let's go ahead at this time. And who is the ADA for Marquise Cobb? All right. Let's go ahead and proceed with position 1, Marquise Cobb. ADA Childers?
Your Honor, my screen just went black, so I wasn't sure if I had been kicked out of Zoom. Can you hear me?
We can see you and hear you.
Okay, I cannot see or hear you.
Okay, but we do, we do see and hear you. So we'll try to, well, looks like she might have frozen up now, so. So, I'm not gonna take one. We'll come right back to one. Is she also the ADA on position 6, Ishmael Keys, who's?
She is, Judge. Yeah.
Okay, and what about on position 2?
She is not, Judge.
Okay, so let's go on and jump ahead, and we'll come back to 1 and 6. Let's take position 2, Kashavion Cody. Okay, all right.
And Your Honor, before I go, I just want to sound for the witness to make sure that they're on. Is Miss Rosier on?
All right. No answer. Let's go ahead and proceed.
All right. I'll go ahead and proceed. Yes, Your Honor, this defendant is before the court on a warrant of trafficking of persons for sexual servitude, was arrested on June 25th, 2025. The general facts that support the allegations right now are that back on June 26th of 2024, DeKalb County police officers responded to Children's Health Care of Atlanta in reference to a sexual assault. When they arrived, they met with the victim, who was a minor, under the age of 16, her mother and her grandmother. During the course of their investigation, they learned that the victim had run away from home and that she essentially had been missing from her home for about a month. Between May and June, she met the defendant along with a female who she believed was the defendant's girlfriend. They offered her a place to stay, but during her stay, they said they were going to kick her out and she wasn't going to have a place to stay if she didn't essentially earn her keep, and that she needed to bring in money for them in order to stay. So then they did force her to engage in sexual acts for money with other individuals at various motels and abandoned apartments in DeKalb County. They then would require her to turn over all the money that she received to them. Mainly, it would be turned over to this defendant, Mr. Kashavion Cody, but sometimes it was also required to be turned over to who she believed was his girlfriend. So that is the basis of the warrant at this time, Your Honor. The charges, the defendant does have criminal history, and it is the basis of why the state is opposing bond in this case. He has a pending theft by receiving stolen property and financial transaction card fraud in DeKalb County. The arrest for that was in August of 2022, and he bonded out on that charge. While this is a misdemeanor, I just want to share it's around the same time, he does have a criminal trespass pending. That was from 2023, also bonded out in 2023 in DeKalb County. And then he has a current possession with intent to distribute of a Schedule 1 or Schedule 2 controlled substance from November of 2023 that is currently pending in DeKalb, in which he bonded out in December of 2023. So he has these 3 pending cases in DeKalb and then picked up this new charge and warrant for this offense. And while those prior offenses are not violent offenses, 2 of the 3 cases are felonies. And so we do believe the defendant is at risk of committing another felony if he is given bond, as demonstrated that he picked up new charges while out on bond for 3 cases. He's also a significant risk to the property, the community of DeKalb, and so we would ask that his bond be denied. And Your Honor, I was notified that the witness who wanted to speak, which is the victim's mother in this case, did just join, so she will speak whenever you're ready to hear from her.
You can sound for her at this time.
Okay, Miss Octavia Rogier, are you present?
Yes, I am.
You need
All
to
right.
turn on your video, please.
Okay. Hello.
All right, hello. If you'll raise your right hand. If you'll raise your right hand, all right. You can swear her in.
Do you swear or affirm that the testimony you shall give this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Can you please state your name?
My name is Octavia Rosier.
Okay. And Miss Rogier, how are you related to the victim in this case?
I'm her mother.
Okay, and can you please tell the court your statement in reference to bond on Mr. Cody?
I want his bond to be denied. He might come out here and grab another little girl. No. Mm-mm. He might come out here and grab another little girl, and no telling what he might end up doing to that little girl. I don't think he should be out.
All right.
Thank
you, ma'am.
Thank you, Ms. Rozier.
Mr. Carter,
And
do
that
you
is all
have
for the
any?
state.
All right. Do you have any questions for her, Mr. Carter?
No, Your Honor.
All right. Thank you. All right. All right. I'll hear from you, Attorney Carter.
Thank you, Judge. Mr. Cody is just 20 years old. Now he's currently living in Lithonia with his mother. He is, he has two children. He has a 1-year-old and a 2-year-old. He does have a bunch of family in the Atlanta area. He was born and raised in Atlanta. He's never lived anywhere else. Prior to his arrest, Judge, he was gainfully employed as a dishwasher at Chipotle. He went to McNair High School, did not graduate from high school, but he did attend Atlanta Technical College and received a GED. He does want to go to trade school to hopefully become a barber one day. Now, Judge, he has been diagnosed with bipolar schizophrenia. He is taking medication at the jail for that. He was getting services at 10 Park Place. He actually has a case manager there. Now, our Mr. Cody denies the allegations in the warrant. So for all those factors, he's not a flight risk. He doesn't know anywhere else besides Atlanta. He's currently living with his mother at the moment. He's gainfully employed. I know that the state emphasized his criminal history quite heavily. However, I did not hear a single conviction. And they did speak about those charges as if it is a fact that he committed those acts. So I do want to point out that he has not been convicted of anything regarding those pending cases. So we are going to be asking for a $20,000 bond in this case. That's going to be our request, Judge.
All right. At this time, I am going to deny bond. I do find that the defendant poses a significant danger to the community, and I'm also concerned that he may intimidate the victim in this case. All right, anyone who is here for that case is excused at this time. ADA Childers, have you worked out your device issue? Okay, looks like you're good.
Yes, Judge.
All right, we're going to go back up and proceed with position 1, Marquise Cobb.
Your Honor, Mr. Cobb has been in custody on a no bond status since July 21st. The incident date is from July 13th. This is an armed robbery located at 7001 Tree Mountain Parkway in Stone Mountain. On July 13th, 2025, at approximately 8:30 p.m., law enforcement responded to the incident location after the victim, Khalees Cole, called 911 and reported that he had been robbed by a friend named Marquise Cobb and 3 other people. The victim told law enforcement that the victim is friends with the defendant's older brother, and the victim and defendant hang out frequently because they live in the same apartment complex. At about 8 p.m., the defendant showed up at the victim's apartment and asked to use a cell phone charger. The victim allowed the defendant inside, and the defendant began charging his phone. About 5 minutes later, there was a knock on the door. The defendant walked to the door, but the victim told him not to answer it because he wanted to check his cameras first. The defendant ignored the victim and opened the door, and 3 people, all of whom were masked and armed with guns, entered the apartment and held the victim at gunpoint. The defendant closed and locked the door behind the subjects after they entered the apartment. The defendant then grabbed the victim's pistol, which was on the living room couch, and joined in the robbery. The defendant and his 3 accomplices took $1,800 in cash and the victim's house and car keys and the Glock pistol before disconnecting the victim's security cameras and leaving the apartment. The victim had security cameras located inside and outside his apartment, and they captured the incident just as it was described by the victim. The victim was able to retrieve the footage and provide it to law enforcement, who then obtained an arrest warrant charging the defendant with armed robbery, and the defendant was arrested on this warrant on July 21st. Judge, his only prior arrest is also from 2025 out of Gwinnett County for theft by receiving and possession of tools for the commission of a crime. The case appears to also be pending. We do have victim contact in this case who has told our office that he is highly opposed to bond as the defendant is a danger to the community, danger to the victim. He held him at gunpoint. Your Honor, the state is also concerned about intimidation of witnesses, given that these parties are known to each other and that family lives in the same apartment complex as the victim. I was told that he would be present on Zoom, but he did not wish to give a statement at this time. He did want the state to reiterate that he is highly opposed to bond due to safety concerns. So we are asking that bond be denied, Judge, due to the previously mentioned factors. He is a danger to the community. He is at risk of intimidating witnesses, and that we are asking that bond be denied.
All right, Attorney Hudler.
Thank you, Judge. Judge, Mr. Cobb is 17 years old. He just turned 17 about a little more than a month before the incident date for this case. He was born in Florida, but he's lived here in Georgia for most of his life. For a decade now. He moved here in the 2nd grade with his family. His entire close family lives here in the metro area. He lives with his mother in Stone Mountain. His mother is present in courtroom 5A and is here on his behalf. He would go to stay with her if released on bond. His sister and his brother also stay with them as well, Judge. Judge, he is a senior at Stone Mountain High School, where he plays on the football team. And he also, although he has not been working because he's a full-time student, he does have a job lined up at a car shop called S&W. His sister is also a manager at Wendy's and has said that he could work there too. As the state mentioned, he does not have any criminal convictions. He does have a pending case from Gwinnett County, but that's the only other thing aside from the matters here. Judge, I'm intrigued by the state's concerns that Mr. Cobb poses a threat of intimidating the listed victim in this case. I understand why they would say that based on the nature of the allegations here, but it's my understanding that the victim in this case has actually been threatening Mr. Cobb and his older brother since these charges arose, because he thinks that they set him up. Mr. Cobb is totally fine with having no contact with the victim. I think that he and his family thinks that's for the best, particularly in light of these threats. Judge, given his young age and his strong ties to the community, his lack of criminal convictions, and the information I just shared about his willingness to comply with the no contact provision, we do think he's a good candidate for a bond. He shouldn't be in jail. He should be finishing his senior year. So we're asking the court to grant a bond of $10,000 with whatever conditions the court finds appropriate.
All right. I am going to set bond in this case. I'm going to set bond in the amount of $60,000. There is to be no contact with the victim or any witnesses or co-defendants in this case. He must report to pretrial services within 48 hours. He must also be on house arrest with electronic monitoring, with exceptions for
Judge, may I speak? I'm the victim.
No, sir. With exceptions for pre-approved exceptions for school or work, if that is approved by pretrial services. All right. So again, my apologies to the victim in this case, but it wasn't announced to me and you can't interrupt once I've already started. All right. So, anyone who is here for the Cobb case, you are excused at this time. We are now going to proceed to position 6. Position 6 is Ishmael Keys.
Your Honor, you broke out just momentarily.
Oh.
The pre-approved exceptions were for work and one other.
Well, for school, really not for work, for school. That would be the only pre-approved exception for school.
Got it. Thank you.
And the usual medical emergencies. All right. Position 6, Ishmael Keys. ADA Childers, is that your case?
It is, Judge. I was just making sure that the defense attorney was ready as well. I did not see them.
I assume Ms. Hudler. Is it Ms. Hudler? Yes.
Okay. Okay.
Yes, Judge. Thank you.
All right.
Your Honor, the victim for this case, Paris Johnson, is also on Zoom today, and I believe would like to address the court at the appropriate time. Again, that is Paris Johnson. This case, Judge, occurred on July 24th of 2025. Defendant was arrested the same day. He is currently in no bond status. It was denied at first appearance. Judge, in this case, the victim, Ms. Johnson, is the defendant's landlord. The defendant lived at a house that she does not live at, along with, I believe, at least one other tenant. And that is at 2551 River Forest Court in Ellenwood. Ms. Johnson received a notification that a package had been shipped to this address, and she asked the other tenant to retrieve it for her. He went to look for the package, told Ms. Johnson there was no package to retrieve. And so at that point, she checked her Ring security camera. And when she checked it, she saw that this defendant, Mr. Keys, had taken the package and actually called out to the FedEx driver and taken the package. It contained a Samsung Galaxy Watch 8 Classic and a Samsung Galaxy Z Fold 7. Together, those two items are valued at almost $3,000. When she confronted the defendant, he denied taking it. But again, there is Ring footage of this incident. As for his criminal history, Judge, he has a theft charge conviction out of Chatham County, which is where all of his history is from. 1995, entering auto theft by taking, simple battery, and giving false name. He was violated on probation in that case. 2001, he was convicted in Chatham County for burglary. 2002, he was convicted in Chatham County of child molestation and giving false name. 2012, he has a failure to register as a sex offender in Chatham County. Also in 2015, removal of an electronic monitoring device in Chatham County. It's a conviction. 2016, he has another failure to register as a sex offender in Chatham County. He wasn't convicted on that case until 2019, and he does have a violation of probation there. The last information I had, Judge, is that Ms. Johnson would be on the call and would like to speak. May I sound for her now?
Yeah, is that Ms. Johnson in the courtroom or?
I saw her on Zoom earlier.
Oh, okay. All right.
Judge, I believe that Ms. Johnson might be under the Zoom under the name Paris's iPhone. The people in the courtroom are family members of Mr. Keys and here on Mr. Keys's behalf.
All right. If you can sound once more, Ms. Childers, for the victim's name.
Paris Johnson.
All right, Ms. Johnson, I need you to turn on your video, please.
Okay. Okay.
All right, if you can raise your right hand. All right, you can swear in, please.
Ms. Johnson, do you swear that the testimony that you are about to provide to the court is the truth, so help you under penalty of perjury?
Yes, I do.
Okay, lower your hand and please share any information you have to the court with regards to your position on bond for this incident.
I don't think that he should get a bond in the sense of I just don't think he should get a bond right now. I'm just not there. I mean, there's other reasons, and I don't know that I'm allowed to express that, but I can't. And I definitely, if you do give him a bond, because I know the judge and you all make that decision, but if you do give him a bond, I don't want him back at my home. And he has his things there, and I asked his family, what they wanted me to do. I've gotten no responses from anybody, but I just there's other factors, and I just don't feel like there should be a bond. I mean, since this thing has happened, I've had people at my home. Apparently, he has things that belongs to other people, and I've had 2 attempts of break-ins, and I've had people threatening. If I don't let them get certain things. I mean, I don't know what I'm up against.
All right, thank you. Thank you, Ms. Johnson. Any questions for Ms. Johnson? Attorney Hudler.
Just a couple, Judge. Thank you. And thank you, Ms. Johnson. I did want to ask something to clarify the package that was at issue here. That was it mailed to you, or had you intended for it to be mailed to the residents?
It was mailed to the residents because that's my account. So I pay all the bills in that house. So my cable company, I ordered the phone through my cable company, so they sent it to the address in which the cable was under. They wouldn't send it to any other address.
Okay, got it. And had you notified just the co-tenant that the package had arrived?
I notified both of them.
Both of them. Okay.
I mean, he opened the package and had it in his possession. So, he opened them, had them in his bag.
Okay. And the incidents that you have described that have occurred since, the problems with others coming to the property, did that all happen after he was arrested, or
it was things? Those things were happening before. However, those things were happening before, and this all just led up to it. This was stuff that was happening with him that was dangerously happening. We just couldn't put your finger on it.
All right. I think I've heard enough. Thank you, Ms. Johnson. All right. All right. And so I don't believe, Ms. Childers, did I hear your specific recommendation? If so, I didn't write it down.
Your Honor, given his criminal history, and the fact that he has been violated on probation a couple times as well, and prior theft charges, the state is asking that bond be denied at this time.
All right, Attorney Hudler.
Thank you, Judge. Judge Mr. Keys is 49 years old, and he is a lifelong Georgia resident. The reason most of his cycles of history are from Chatham County is because he grew up in Savannah, and still has a good deal of family here, or in Savannah. However, he also has family locally here as well. As you can see, he has family members who are here on his behalf in courtroom 5A. I think those might be his step parents who live in Union City. Judge, he studied education at Savannah State, and he used to work as a teacher for children with special needs, is my understanding. Judge, we do think that there might be some mental health issues at play here, and that's kind of the root cause of the allegations that have come out of all this. He has been referred to a social worker with my office. I do think he would not have an issue with abiding by a do not return provision to the home, so long as he be able to get his belongings. I believe that his step parents live locally, and so he could stay with them. At this time, I would like, if the court will allow, if we could hear from one of his family members who's present in the courtroom to speak on his behalf.
All right. All right. I believe, ma'am, if you can come forward a little closer and raise your right hand, please. That's good where you are. Thank you. And you can swear her in.
Okay, thank you so much. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Thank you so much. And ma'am, could you please state your name for the court and how you know Mr. Keys?
My name is Fatima Coates. I am his sister, and this is his father behind me.
Okay, thank you so much, Miss Coates. Can you please share with us your opinions on whether your brother, Mr. Keys, is a good candidate for bond and why or why not?
So Ishmael, I know he's been in a, back and forth and mixed up in a lot of things, but he is schizophrenic. We do know that. When he was out this time, he would start off good taking his medication, but then would slowly drop off, not being able to take his medications. We have not spoken to him since he's been in jail. I don't know why, if he doesn't have the numbers or anything, but anyway, I think Ishmael could be productive in society if he would be able to go to a mental health long-term facility just because he has the schizophrenia. And I know it when I talk to him on the phone, and I know when he's not taking his medication. I don't know if he's receiving it while he's in jail though, because I haven't been able to talk to anybody, but he needs to be taking his medicine. He's a much better and productive person when he's on his schizophrenic medications.
All right. Thank you.
Thank you. Thank you very much.
Any questions, Attorney Childers?
No, Your Honor.
All right. Any more questions, Attorney Hutler, for Ms. Coates?
Judge, I'm not sure if it's a question really, but I think one reason why we didn't know family would be here is because we didn't have any numbers for family because Mr. Keys didn't. It's precisely what his sister had just said. So I would ask, maybe typically I would say I'll put my information in the chat or something, but I guess I would just ask Ms. Coates and Mr. Keys' father if they could call the public defender's office. We can get everybody in touch with each other.
All right. All right. All right. I'm pretty sure she wants to know the phone number. Is that what you?
I mean, where do I, is it here in the cab or how do I?
Do you want to give her the main number at this time?
I thank you, Judge. I appreciate it. Yes, ma'am. Our office is in downtown Decatur, right near the square, right near the courthouse. And I can give you the phone number for the office to call.
Okay.
Go ahead.
It's 404-37. And Mr. Keys' assigned attorney is Attorney Hydrick, Hydrick.
All right. Thank you. All right. Ms. Coates, you can be seated. Thank you very much. And I'll hear from you, Attorney Hutler.
Thank you, Judge. Given in light of the information that Ms. Coates has shared, we are asking the court for a low bond because I think it's all that Mr. Keys can afford, but with whatever conditions the court finds appropriate, including a mental health evaluation and recommended treatment, because it seems that is indeed what is necessary here. I think what he could afford would be something in the neighborhood of $100 cash bond, Judge.
So I am going to set bond in this case. I'm going to set bond in the amount of $7,500 with the following conditions. He is to not return to the incident location. He is to have no contact with the victim in this case, and he is to submit to a mental health evaluation and follow the recommendations therein.
Judge, may he have one supervised trip with a deputy to get his belongings from the home?
All right, so I will allow one, one supervised visit with law enforcement to retrieve his belongings.
And Your Honor, is there a certain amount of time that he has to complete that mental health evaluation, 30 days, 60 days?
we'll put it at 60 days. All right. All right. At this time, so anyone who was here on.
Okay, yeah. Like I said, I've had my eye on this court for a while, and I think it was a worthwhile stop. I'm going to keep an eye on him. We may come back. Let's go down to Miami-Dade, spend a little more time with Judge Glazer. She actually took a like an extended breakfast break, so I'm curious to see how that affects her mood.
Victim's driver's license, his girlfriend's driver's license, credit cards, and they found them after a search warrant. They found the victim's items as well as their fishing license, medical cards, credit cards in his home. So count one, burglary of the unoccupied conveyance is $2,500. Okay, next case is F25-18004. This case, you're charged with burglary to an unoccupied conveyance. It's from August 4th, broke into the victim's vehicle, their Lexus, and they found the victim's property in his home, including the victim's driver's license, 10 credit cards, and 2 other identification cards. Bond is $2,500. Next case number is F25-18003. This is from August 4th as well, where he burglarized the victim's vehicle. He's wearing that house arrest monitor, so they're able to track him, and they found the victim's blue tote bag in his home. Bond is $2,500 with the hold. He has a hold on all cases, so I don't need to keep repeating that. Next case is F25-18002, which is a burglary to an unoccupied conveyance. This is from January 1st of 2024. So the victim's multiple credit cards, as well as other personal identifiable information cards belonging to the victims, were found in his home. So there's probable cause for the charge, $2,500 bond. Next case is F25-18001. This is a armed burglary to an unoccupied conveyance and fraudulent use of a credit card from August 1st. Victim's car was burglarized. His gun was stolen. Tools were stolen. And he then used the victim's credit card at Target. So after the burglary, he used the victim's credit card and charged $103.68. He may have other charges coming, I don't know. But a lot of the items were found in his home except the gun. So count one, burglary to the unoccupied conveyance while armed, is no bond. It's an armed burglary, so it's no bond. You're gonna have to go before the division judge and have what's called an Arthur hearing to see if you can be released from jail pending the arraignment or trial. Count two, fraudulent use of a credit card over $2,500 is $2,500. I'm sorry, over $100 is a $2,500 bond. Next, we have F25-18000. This is a burglary to an unoccupied conveyance from January 7th of 2025. You are ordered to stay away from the Sovereign's condominium at 6851 Southwest 147th Avenue in Miami, Florida. You are not allowed to go to that location. You must stay away from there. There is probable cause for the charge. They found multiple insurance and credit cards in his master bedroom after the execution of the search warrant. Bond is $2,500. Next, we have F29-17999. That's from August 19th, which was yesterday. You're charged with burglary to an unoccupied conveyance. So in this one, the victim's car was burglarized. They found the victim's property, driver's license, and multiple credit cards at his residence. Bond is $2,500, which makes you wonder why so many people get their driver's license in their car. That's smart. But so then we have F25-17998. This is from July 26th of 2025. So victim's vehicle was burglarized. It found property belonging to the victim, including his glasses inside Mr. Ricardo's residence. So the bond is $2,500. And we have F-25-17997, which is from July 31st of 2025, burglary to an unoccupied conveyance. There is probable cause for the charge. They found the victim's blue iPad in a pink case located in his garage. So there's probable cause for the burglary, $2,500 bond. So sir, we're all done with your 11 new cases. You're going to see Judge Venzer tomorrow regarding your hold for the vehicular homicide case where you allegedly killed 2 people driving. Good day. Give me 1 second. There's somebody in the courtroom I need to speak with.
Okay, well, she goes and speaks with whoever it is she's speaking with. Let's head over to Louisiana, make our world-famous stop there with the Board of Pardon and Parole, a regular here at TCF.
Today, to my left is Mr. Tillis. To my right is Mr. Barra. Would staff at headquarters please identify themselves? Okay, officer, would you please identify yourself, please, sir?
Yes, sir. My name is Carl Kamlak, Video Conference Office.
Okay. Carl, do you have any contact with the inmates? You know anything about him since he's been there?
No, sir. No, sir. I just handled a video conference.
Okay, I got you. Okay, today we're here for the hearing on Rodney Miller. Mr. Miller, could you state your name and DOC number, sir?
Rodney Miller, 769954.
Okay, Rodney, do you have your parole questionnaire with you?
Sir?
Your parole questionnaire. That's to say whether you could have an attorney or not. Do you have that with you?
No, sir.
Okay, can we put it up on the screen, please? Okay, you see that paper?
Yes, sir.
Is that your name at the bottom?
Yes, sir.
Okay, that says that according to our guidelines, you wasn't eligible for appointed counsel. If you wanted counsel, you would have had to retain it. Do you want counsel today or do you want to proceed?
Proceed.
Okay, do then. Okay, your hearing was assigned to me, Mr. Miller. So I'm going to go on and read your violations. And as I read them, I want you to plead guilty, not guilty, with a statement or without a statement. And then I'll let you explain each violation, you know, if you wanted to make a statement. You failed to report within 48 hours of being released from detainer. You were given 30 days to report, which you failed to do. You failed to report to your parole officer for December 2023, January through December 2024, and January through June of 2025. You failed to provide your parole officer with a valid address where you could be contacted. How do you plead to those violations?
Not guilty.
Okay. You want to make a statement? I mean, why you plead not guilty?
Okay, not guilty for the first one, for the not reporting in 48 hours. I was still incarcerated once I got released from River Bend. I had a hold for Mississippi and I had to go to Mississippi within them 48 hours. I was still locked up right then. And once I got released, after them 30 days, once I got released from Mississippi, when they had jurisdiction over my body, they wouldn't let me go report to Shreveport because they said I was on ERS. early release, and I couldn't go nowhere out of state until I was done with that.
Out of what state?
Out of Mississippi.
Out
They
of
told me I couldn't. They told me I couldn't come and report to Shreveport because I was still on ERS in Mississippi.
Okay, what about January through December 2024 and January through June of 2025?
January, June. See, I got locked up last year, November.
Okay,
So
time before that. Okay, and you failed to provide the parole with a valid address. Where are you going to be living? Where you live?
Right now I was living in Texas right now at the time because I didn't have an address. That's where I was staying at. But I got released. I got released to Mississippi, and they told me I didn't have to put no address in because I was getting released to another institution.
But you never called or reported to Louisiana at all?
I called my parole officer and the supervisor that was over her and explaining to them and letting them know everything that's going on with Mississippi. I was briefing them about everything that they was telling me that I couldn't come, why I couldn't come. I briefed them about all that.
Well, first off, we're not going to get into that, but Mississippi cannot keep you from coming and report to Louisiana, first off. But anyway, okay, do my colleagues have any questions?
Go ahead. What do you plan to do if you're released? Where are you going to live?
If I had to get an address, I'd be able to provide an address.
You're going back to Texas?
No, I'm not going there. But if I had to provide an address down here or something like that, then I'd be able to do that and report and do all that like I was planning to do the first time. But they wouldn't let me go report, so it's nothing I could have did.
But you were out too, though. Wasn't you out of jail? You wasn't in Mississippi the whole time.
I was out of jail soon I got out. I was in Mississippi, and then I was on parole in both times in Shreveport and Mississippi at the same time. So I was in Mississippi almost the whole time before the situation happened.
But you did leave from Mississippi and go to Texas.
Yes, sir, because I stopped reporting.
Mississippi would let you do that?
I stopped reporting to Mississippi because they wouldn't let me come report to Shreveport, and I'm already was gonna get violated.
You probably could have avoided all this if you'd have just come to Louisiana on your way to Texas.
I would have got violated in Mississippi then.
You weren't worried about that by that point.
They wouldn't let me go at first.
So where are you going to live? You know, you said if you had to provide an address, we're asking you to provide an address, where would you be living?
It got to be in Louisiana, right?
No.
But you got to
but you got to go to the Louisiana Probation and Parole Office and apply for your interstate compact and get accepted the right way. You can't just go. You gotta apply for it and you gotta get approved for it. You know, you can't just go wherever you.
So I'll say Texas where my kids at.
All right.
I have any more questions.
You have any more questions? No. Okay, we're ready to vote now. I find you not guilty on condition number 1, report within 48 hours. I do find you guilty of condition number 2, because you did leave Mississippi and go all the way to Texas, yet you never stopped in Shreveport. My vote today is to revoke. Mr. Tillis?
My vote is also to revoke.
Mr. Barrow?
I'm going to concur with Mr. Tillis and Mr. Freeman for the same reasons. You needed to contact Louisiana.
Right. Okay, your parole has been revoked today. Good luck to you, sir. And is that the only one that we'll be signing out at Madison at 9:01?
All right, thank y'all.
Denied.
Okie dokie then. Not a surprise. That's normally what we see. So let's do something completely new. I have never been to this state before on this channel. Let's go to Nevada. Reno, Nevada specifically, where their municipal court is doing jail arraignments. So let's see what that's all about.
And there are citations and or complaints. We'll waive a formal reading. For those in our no contest plea, we'll stipulate to a factual basis.
Thank you, sir. Out of courtesy, let's take Mr. Ferendorf's matter first, if we could. Mr. Ferendorf, I'm going to guess that you're here for Mr. Guzman. Is that correct, sir?
That's right, Your Honor.
Let me pull up his file. Mr. Guzman, if you'd come forward, please, sir. Good morning, Mr. Guzman. Good morning, Mr. Guzman. Your microphone is muted.
Good morning, Your Honor.
Thank you. Your case number is 25 CR 07972. I believe you were taken into custody yesterday at the Reno Municipal Court for violating a court order, and that order was that you remain alcohol-free pending your trial date, pre-trial. You were charged with offenses from June the 7th, 2025, sir, minor purchasing or consuming an alcoholic beverage in public, as well as DUI alcohol first. And then, of course, you were arrested based upon that outstanding warrant. Sir, do you admit or deny that you are in compliance or that you failed to comply with the court's order by using alcohol?
I admit, Your Honor.
All right, sir. And you understand your constitutional rights?
Yes, Your Honor.
All right. The maximum penalty for contempt of court, sir, could be up to 25 days in jail and a fine up to $500. Are you aware of that?
No, Your Honor.
All right. So now you know that if you violate the court's order, you could be serving 25 days in jail, regardless of whether or not you've got a great lawyer and he's able to get the charges reduced or dismissed. You would still be in jail for 25 days for violating the court's order. You understand?
Yes, Your Honor.
All right, sir. Have you served in the United States military?
No, Your Honor.
All right. I'll accept your admission as freely, voluntarily, and knowingly entered. Mr. Guzman, was this the longest that you've been in custody?
Yes, Your Honor.
All right. I note that you're, I believe, 20 years old. Yeah, you just turned 20.
Yes, Your Honor.
So what I'm going to do then, sir, is I'd like to hear from counsel, but I intend to release him with some conditions. Mr. Ferendorf.
Your Honor, I would just say that, based on, I do appreciate the comment about whether or not the lawyer is good enough to get this reduced. Any lawyer who is barred could get this reduced. The blood alcohol content is an 03 and an 04. He was arrested, and the arresting officer had a misinterpretation of the law and believed that if you weren't 21, that there was an 02, that the 02 was the limit. And so I do believe that Mr. Guzman should be released today. He has, he's 20 years old, and his frontal lobe has not been developed yet. I know that doesn't develop in males until 25. I do believe that spending this amount of time in custody on this offense, I believe that it has made an impression on him, and I am sure that he does not want to go back to par. And so I would request that he be released today and that we proceed with trial tomorrow.
Thank you. And Ms. Yowell?
Your Honor, I have no objection to him being released. I would like him on supervision just because I don't have all of the information, and I do understand and respect Mr. Ferendorf's position. I have reviewed the low PBT, but there could be other information that surfaces between now and the trial date, which I understand is tomorrow.
All right. So, Mr. Guzman, I'm going to release you today, and I hope that this little taste of jail is enough to remind you that whatever happens tomorrow at trial, you're still 20 years old. You're not allowed by law to have alcohol in your system, and basically, as your lawyer indicated, your brain's not fully developed until you're 25. So until I see you tomorrow. I'm not going to require you to test today because I frankly think that you've gotten the message. So I will see you tomorrow for trial. You're released on your own recognizance today with those conditions. Do you have any questions, sir?
No, Your Honor. Thank you.
All right. We'll see you tomorrow. Thank you, Mr. Ferendorf.
Thank you, Your Honor.
Judge, is he getting time served on the contempt charge, or?
Yes, he is. Time served.
And then just to clarify, so he's back on, is he on basic supervision or?
Well, since it's one day, it would be medium supervision if he had any longer to be, to wait for a trial. But just in abundance of caution, if he decides to go out on a bender today, the marshals have the authority to test him today or tomorrow if they feel it's necessary.
Okay, so I'll put down medium supervision.
Medium supervision.
Thank you.
Thank you, Mr. Ferendorf.
Thank you, Your Honor.
All right. Good morning, ladies and gentlemen of the jail. Thank you for your patience this morning. My name is Shelley O'Neill. This is the time set for video arraignments. An arraignment is your first appearance before a court, where what will happen is as follows. I'll call your name. You'll come up to the table in the front of the room. The little black object in the middle of the table is a microphone. So please stand as close to the microphone as you possibly can. And please note all of your answers to any questions that may be posed audibly. That means you need to speak up. You can't just nod your head one way or the other if I ask you a question, because nodding does not get picked up on our recordings. I will go over your charges, ask you if you understand the charges, then I will take your plea. As you know, you have three options here this morning, unless you're doing something else, and we have some other matters that we'll deal with sentencing and the like. But generally, you can enter a plea of not guilty. We'll set the matter for trial. Trial is usually set within 30 to 45 days. You do have a state constitutional right to have your trial set within 60 days. That's your speedy trial rights under the state and the United States constitutions. All trials are held in person. We don't do Zoom trials. And if you have evidence or witnesses that you wish to present at trial, please bring them with you on the date that's set. I will tell you that if you are charged with one of the more serious misdemeanors, such as DUI or domestic violence, those are the types of offenses for which you could receive jail time. And so I'm obligated, if you cannot afford your own lawyer, to appoint a lawyer to represent you. I'm going to do something unusual, and that is I'm going to order that you make contact with your lawyer prior to the trial date so the two of you can be prepared to proceed to trial. Many people, particularly those charged with their first offense, don't realize that they have to speak with the lawyer and go over the facts of the case in order to put together, obviously, a productive defense. We will be giving you the names and contact information of your assigned counsel. And if you don't get it when you're released from custody, then I'm going to direct you to the Reno Municipal Court, which is located at 1 South Sierra Street, or you can call or email them and they will give you the contact information for your lawyer. Also, almost everyone who's released pending trial on a not guilty plea will have certain conditions for their continued release from custody. And they are that you obey all laws, you have no alcohol or drugs without a valid prescription, including marijuana. And in cases that involve violence against another person, you'll probably have a no contact order if that's been requested from the prosecution. That being said, the jail gives me a special attention list that they'd like me to address first. And I'm going to go to that now. The first person that I have on that list is Patrick Mall. So Mr. Mall, if you would come forward, sir.
You're the judge or the lawyer?
Sorry, am I a judge or a lawyer? And both. So stand a little closer to the table, sir. Thank you. See that black object? That's the microphone. Good morning, Mr. Mall. Good morning.
I remember when I did what I have when they released me.
All right, Mr. Mall, this is a case 25 CR 12061. This is listed as a sentencing hearing.
That's what I have as well, Your Honor.
It looks like on August the 15th, sir, you entered a plea of no contest to the charge of simple battery. Did you recall that?
Yeah.
All right.
They dropped over container. No, I didn't.
Okay. Well, you have just a simple battery to be sentenced on today. And I'll hear from the city attorney. Are you prepared to proceed, Michelle?
Yes, I am, Your Honor. And Your Honor, we do not have the victim here today, but I am ready to go forward. So I'll start if you'd like me to do so.
Let me ask Mr. McGinnis if he's prepared to proceed.
Yes, I am. Thank you, Judge.
You're welcome. Go ahead, Michelle.
Your Honor, this incident occurred at the Walgreens on North McCarran. It appears that the defendant was extremely intoxicated. He had an open container and he ended up throwing a bunch of magazines at the victim. I don't believe he knows the victim. However, I am not sure. The magazines ended up hitting the victim. The pretrial risk assessment score on this defendant was a 13. I don't have, I wasn't able to access the actual criminal history. So based on all of the above, I'm going to ask for a small suspended sentence with a no alcohol clause and a no contact or stay away order from the victim. 30 days, no alcohol or drugs, stay away from the victim, and stay away from the Walgreens.
Is that you're requesting that to be a suspended sentence or an imposed sentence?
A suspended sentence, Your Honor.
Thank you, Michelle. Mr. McGinnis?
Thank you, Your Honor. I did review the record. It appears that my client also goes by Patrick Shockley. That's an AKA he has. He's listed as the Patrick Mall today. In 2019, he had an incompetency finding underneath, I believe, the name of Shockley. I believe he's competent to go forward today. I will note that he does have a case manager down at the CARES campus. He plans on going back there. He also indicated that he will go to community court for other resources on Wednesday morning. That would be next Wednesday morning. Hopefully he can maintain some sobriety and stay out of trouble.
Thank you, Mr. Mall. What is your true name then, Mr. Mall? Is it Shock?
Boy, Mall. Chuck is my last girlfriend.
Okay. All right. So, Mr. Mall, what would you like to tell me about this incident? You understand that it's not.
I gotta time anyway because I get my pills and they don't give it to me out there. They don't give it to me here. If it's not cold out, then if it's cold, I don't know what I'm gonna do. The care center is always full.
Well, I want to know if you understand that it's not okay to try to hurt somebody by throwing stuff at them or hitting them with something. You know that that's not okay?
I wasn't drunk.
Well, that's not the question I asked you.
No.
Whether you're drunk or sober, you know that you can't use violence against another person.
I didn't.
Okay, well, the allegation is, and that you pled to, sir, is that you threw something and hit someone who's an employee at Walgreens.
Oh, I'm sorry if I did, but I don't remember doing that. I wasn't drunk.
Okay.
I didn't steal anything. I had money. People give me money.
All right, Mr. Mall, based upon the fact your risk assessment is 13, that you were intoxicated at the time, but that you hurt someone or tried to hurt someone by throwing something at them, I'm going to sentence you to 60 days in the Washoe County Jail. That sentence will be suspended for a period of 2 years on the condition that you obey all laws, you have no alcohol or drugs without a valid prescription, including marijuana, and that you have no contact with the alleged victim in this matter, and that you stay away from the Walgreens on North McCarran. You're probably 86 from all Walgreens based upon your behavior. So you may have to use another pharmacy. Do you understand, sir? Do you understand the conditions of your suspended sentence? I'm going to order that when you're released from jail that you need to go to the Reno Municipal Court and set up your supervision with them, okay?
Okay, no, okay.
All right, good luck, sir.
Oh, thank you.
The next matter is Kevin Bobos.
Your Honor, he was sent back. I'm going to request that a competency evaluation be done on him.
All right. Any objection from the city?
No objection.
All right, we'll continue the matter until, we'll continue the matter with a no bail hold, and I will order a competency evaluation for Mr. Bobos in case 25 CR 08875. The next matter then I have is Catalina Johnson.
Your Honor, she refused.
All right. We'll continue Ms. Johnson until tomorrow. Kylie McClatchlin, Beaudre.
She also refused, Your Honor.
And what number of refusal is this, Deputy O'Connell?
It's her first, as far as I know.
Okay, we'll go ahead and continue her until tomorrow. Has bail been set in her matter? Let me look. Sorry, I refer to him, Mr. McLaughlin. He has two matters before the court, 25 CR 10752.
Your Honor, it looks like bail's been set on both.
Very good. It's a paraphernalia and a failure to appear in that one. So we'll continue Mr. McLaughlin until tomorrow's bail here, videos. The last person I have, oh, no, sorry, I have a few more. Yosef Elias. Good morning.
Good morning.
Ms. Elias, your case number is 23. Oh, you have two matters this morning. They're both, one is an old criminal case, 22 CR 15995. That's a 3-year-old charge of embezzlement arising from December the 9th, 2022. It looks like you were alleged that it's alleged that you failed to appear for court on February the 9th, 2023. And let's see, there's probably an outstanding warrant for your arrest. You find that. All right, a warrant was issued for your arrest, Ms. Elias. I'm going to read you the warrant so you understand why you're in custody. A warrant was issued by Judge Justin Champagne on March the 16th, 2023 for failing to appear for court on February the 9th, 2023. Did you appear for court on February the 9th, 2023?
No, Your Honor.
So are you admitting that you failed to appear?
That is correct.
All right, and you understand that failing to appear is contempt of court, for which I could sentence you up to 25 days in jail and fine you up to $500?
Yes.
Did you understand your constitutional rights?
Yes.
And have you served in the United States military?
No.
The court will accept your admission to the failure to appear as freely, voluntarily, and knowingly entered. Why didn't you appear, Ms. Elias?
I was recently going through a divorce and I am a single mother of 5 children.
Okay. All right. Well, I'll deal with the sentencing on your failure to appear in a moment. Let's take your plea. You were originally charged in that matter with the crime of embezzlement. Do you understand the charge?
Yes.
All right. And so since you have another matter, let's deal with that as well. And that's 23 TR 06687, which tells me it's a 2-year-old traffic case. And sir, ma'am, this is a June 14th, 2023 charge of registration required and operator proof of insurance, which, excuse me, again, you're alleged to have failed to appear for those charges on July the 18th, 2023. Did you appear for court on July the 18th, 2023 for the traffic charges?
I did not.
So in the same questions, do you understand that failing to appear is contempt of court?
Yes.
And would your answers relative to your constitutional rights and your service in the military be the same?
For that one, my son was hospitalized in the border of life and death.
And what happened?
We were in a car accident and he was ejected from the vehicle.
And what date was the car accident?
It was May 5th.
All right. And so 2 months later, he was still in the hospital?
He was in the hospital for 6 months in the ICU unit.
All right, I'll go ahead and dismiss that failure to appear based upon your medical excuse. I think that's a legitimate reason for not appearing for traffic charges. Is the city prepared to tender an offer to Ms. Elias relative to the traffic matter?
Your Honor, the city would request if the defendant were to plead to the charges that she be allowed to be given the opportunity to cure the charges. The city would be willing to move to dismiss the registration.
Thank you. So basically, the city attorney is offered to dismiss the registration charge, Ms. Elias, if you want to enter a plea to the not having insurance on the day in question. Do you want to accept her offer?
Yes.
And what is your plea to not having insurance on June the 14th, 2023?
I was going through the same thing with the
No,
situation.
hold on. That's basically a one-word answer. If you want to accept the offer, you can enter a plea of guilty or no contest.
Guilty.
All right, and you understand by entering a plea of guilty, you're giving up your trial rights here today.
Yes.
Well, let's go back to what is your plea to the embezzlement charge and the other matter?
Guilty.
All right, so both of these questions apply to each one of these charges. Do you understand that?
On the embezzlement, what if I do no content? Would I be able
Okay.
to pay it back or?
Well, you're probably going to be required to pay restitution whether you enter a plea of guilty or no contest. You're free to do either one. There's no difference in sentencing with either one of those pleas.
I'll remain this, no content.
Okay, no contest to the embezzlement
Yes.
and guilty to the no insurance?
Yes.
All right, and the same questions, you understand first that by entering a plea of no contest, the court, which is me, will find you guilty of the embezzlement charge?
Yes.
Did you understand? You understand your constitutional trial rights as to these two matters?
Yes.
And the maximum penalty for each of these could be up to 6 months in jail and or a $1,000 fine. Are you aware of that?
Yes.
And we've already established that you're not a veteran, so I'll accept your pleas as freely, voluntarily, and knowingly entered. As to the insurance charge, I'm going to do the same thing I do with everyone. And I'm going to fine you today $748. However, I'm going to continue this matter. How long would it take you to get insurance after the fact? Do you have insurance on your vehicle now?
No.
Okay. How long do you need to get insurance? Because I'll tell you why I'm asking. Because if you can go out and get insurance in the next 60 days, which I'm inclined to give you that period of time, I'm allowed to reduce your charge down or your fine down from $748 to $200. It saves you more than $500. Do you want to try to get insurance in the next 60 days?
Yes.
All right, so we'll go ahead and do that. So I will fine you $748 today and reduce the fine down to $200 upon proof shown by on or before October the 20th, 2025. Okay, so your obligation. So if and when you're released from custody, you're going to need to go to the Reno Municipal Court and set up the agreement I've just made with you that if you get insurance, I'll reduce the fine. Okay?
Yes, Your Honor.
All right. Now, as to the embezzlement, I'll hear from the city. I'd like to know what the amount of loss was, and if you'd like to make any comments relative to the sentencing, Michelle.
Yes, Your Honor. So in looking at the facts of this case, the defendant was an employee of Ross. It's alleged that she ended up taking $55.96 worth of merchandise. So while it's not a huge amount, the fact that she was an employee, the city would like the opportunity to see if Ross would like that money back. However, there are two concerns. Normally, because the amount is low and all of that, and I understand the defendant needs to get out and get her insurance to cure that charge, I would ask for an out of custody sentencing. And I'm still going to do that just because of the low amount, but I am concerned about the failures to appear and the length of time that she has been missing. So perhaps she could be on pretrial or on supervision pending her sentencing date.
All right, I'll hear from Mr. McGinnis.
Thank you, Aaron. These are super old cases. It doesn't appear like she's been in trouble since 2023. If the city's requesting an out of custody restitution hearing, I could understand that, or sentencing.
All right. So Ms. Elias, what we're going to do is I'm going to release you today on the embezzlement charge. As to the, and I'd like to hear from you about that charge and the failures to appear. I think you have indicated that you had some trauma in your life relative to your child being injured in a car accident. But these are both very serious charges, and now you're in jail. So I don't know about the single mother of 5 children. How are they faring while you're in jail?
My mother is with them at the moment, but she has medical complications as well.
Okay. Well, I think you understand now I hope you understand now how important it is that you make your court appearances, because you would not be in jail on either one of these charges if you merely appeared for court. Do you understand that?
Yes, I do, Your Honor.
All right. So as to each of the failures to appear, I'm going to sentence you to 10 days in the Washoe County Jail. That will be 20 days in the Washoe County Jail, suspended for a period of 1 year, on the condition that you obey all laws and you make any and all future court appearances. Do you understand that if you break the law or you don't come to court because I'm going to set another hearing for you, you'll be out of custody. But if you fail to appear for that court hearing, you'll go to jail for 20 days. Do you understand?
I understand, Your Honor.
All right, so we'll set that for a court hearing, and I will be releasing you and what you're going to have to do is come back to my court. The city attorney will contact Ross and see, someone will be there with proof to make a determination about whether or not they want that $53 back, okay?
Yes, Your Honor.
All right, so may I have a date for an out-of-custody sentencing hearing for Miss Elias?
Yes, Your Honor. In Your Honor, I need clarification, please, as well. That restitution hearing would be September 22nd at 1 p.m. And in the traffic case, I believe Your Honor already dismissed that failure to appear.
You're right. Thank you. So
You're
it'll just
welcome.
One 10-day sentence. Thank you. I forgot about the dismissal based upon the medical.
Okay. Was it 10 days suspended?
Yes.
For a year. Okay. Thank you.
Thank you for the reminder. Thank you. All right. So Miss Elias, you're going to be required to appear in my court on September the 22nd at 1 p.m. Okay. But you understand that if you don't appear, you'll be subject to obviously new failure to appear charges, and you could be revoked on the 10-day suspended sentence.
Yes.
And Mr. McGinnis, do you wish to be heard?
No, I'll submit it, Judge.
Okay. All right. So Miss Elias, do you have any questions about what I want you to do here today?
I do not, Your Honor.
All right. So it's really important that you go out and get insurance. Do you have a car?
Yes.
Okay. So go out and get insurance on that car and make sure that you can bring proof to the court within the 60 days I've given you, October the 20th, and we'll reduce the fine. The fine will be $200, and you can set up a payment plan for that $200 if you need to do that, okay?
Yes, Your Honor.
And then I will also see you on September the 22nd at 1 p.m. To make a determination as to what we do relative to the embezzlement, okay?
Okay.
All right, you should be released today.
All right, thank you,
And Your Honor, could we ask her to report to set up that proof for pay, please?
Yes, please report to the Reno Municipal Court in the next day or so. We're closed on Friday, but today or tomorrow, so you can set up the agreement that I've just made with you relative to the insurance, where I have agreed to reduce the fine down to $200 if you get insurance, okay?
Yes, Your Honor.
All right, you're released. Good luck.
Thank you. Okay.
Mercedes Marquez.
Hello.
Good morning, Ms. Marquez. Your case number is 25 CR 12189. And you were charged on August the 18th, 2025 with domestic battery first offense. Do you understand the charge?
Yes, Your Honor.
And is it your intention this morning, Ms. Marquez, to enter a plea of not guilty and schedule the matter for trial?
I would like to, even though it was an accident, I'd like to plead guilty.
You may want to talk to Mr. McGinnis about that. Shall we, Mr. McGinnis, do you want to have some time to address your client's decisions here this morning?
I think I did speak with her in great detail about this case. The criminal complaint was filed a little bit later, so I had to call her back up. So we did have two separate conversations. I advised her to enter a not guilty plea. Mercedes, are you changing your mind now? Do you want to have more conversation about that?
I mean, I just honestly am eager to get out and get the program going. And I understand that if I do not guilty, that I'm going to have to do more time.
No. Okay, stop right there. So Ms. Marquez, I really hate when people give up their constitutional trial rights just to get out of jail. Because listen to me for a moment. This is the most serious misdemeanor there is. And I don't know what you do for a living, but if you have a domestic battery conviction, it could keep you from employment. It could affect your child custody status. Obviously, there are big fines and fees and suspended sentences and all that sort of thing that go with it. And I will tell you in all candor that I'm not sure who your victim was because I haven't looked at the complaint, but many times the city attorney has to dismiss the charges because the victim is usually a spouse who doesn't want to see you convicted, so they don't come to court. So you may want to take all of those considerations into effect. I do not recommend anyone pleads guilty simply to get out of jail.
I'll plead not guilty. I'm sorry about that.
Thank you. Can you afford your own lawyer, Ms. Marquez?
No.
I'll appoint a legal defender to represent you. May I have a trial date, please, with a legal defender for Ms. Marquez?
Yes, Judge, I have October 2nd at 8 a.m. with Kyle Edgerton.
I'm sorry, can you repeat that? I missed that.
Yeah, I'm going to give it to you again. October the 2nd at 8 a.m. and your lawyer assigned is Mr. Kyle Edgerton. I will order, Ms. Marquez, that you do make contact with Mr. Edgerton prior to the trial date. So usually about a week to 10 days is when they get the paperwork for your case. So you need to contact him in about a week to 10 days so the two of you can discuss your possible defenses. Do you understand?
I do.
All right, now what we're going to do is discuss your bail situation and whether or not you're going to be released from custody. So let me look and see. Looks like the complaint has just recently been filed. So I'm going to guess that no, has any bail been set, Deputy O'Connell?
No, Your Honor.
All right, I'll hear from the city as to bail.
Your Honor, going through her criminal history, her pretrial risk assessment, I believe, is an 8. Let me just make sure I'm remembering that correctly. Yes, it is an 8. And I will let the court know she has several violent charges in her history. She has a domestic battery that was amended to a simple battery in 2017. She has a battery in 2014, a provoking assault. And some of these are arrests, which are appropriate for bail, but some, as I indicated, the domestic that was reduced to simple was a conviction. I am concerned with the violent history. So let's see, she also has out of Sparks, it looks like another battery for which she pled guilty. There's a domestic battery arrest and an interception, like a delay message via phone line in 2017. We have, yeah, there's a history of violence. So based on that, I'm asking for a minimum of a $3,000 bondable bail with no contact with the victim and no alcohol or drugs, Your Honor.
Thank you. Mr. McGinnis?
Thank you, Your Honor. I see that there is the Nevada pretrial risk assessment of an 8. My client's been in the community for the last 27 years. Unfortunately, it indicates that she doesn't currently have a fixed address, yet she does have a full-time job. It appears that there's no failure to appear on her Nevada pretrial risk assessment. I could tell the court that she has made applications to the Crossroads program. She currently doesn't have a bed date, but she's hoping to participate in the Crossroads program here in the near future. That's one of the reasons why she was wanting to enter a plea to get out of custody. I'll submit it based on that, Your Honor.
Thank you. Ms. Marquez, what do you do for a living?
I work at Taco Bell. I'm on a maternity leave, but I'm expected to come back very soon, and I was trying to come back as soon as I can. I'm just trying to move on with my life. I haven't, done anything ever since my first child was born. She just turned 7. So all I want is to provide a better future for them.
So you've been on maternity leave for 7 years?
No, I just had a baby July 31st, my fourth child.
Okay.
Yeah, I've
And
been on
who has
maternity leave,
custody
but
of
I'm
that
expected
child?
to come back. I have custody of it, but I've been planning on going to Crossroads and they were just waiting for me to have the baby. So then I decided to let them go to their father's house with their grandmother. But I was still with their father, and then all this happened over an argument. But I'm still focused on the future, still focused on trying to be better, still focused on all the goals that I had set up already.
All right, based upon the fact that you're a new mother and that you're seeking some counseling, I'm going to reduce your bail down to $1,000, which means that you can post bail in the $100 to $150 amount and be released from custody. The conditions of your release, though, will be, as the city attorney has reminded, that you are to obey all laws. You're to have no alcohol or drugs without a valid prescription, including marijuana. I'm going to put you on medium testing with our Marshals Division and order that you basically have no contact with the alleged victim in this matter. Do you understand?
Yes.
Is the alleged victim your partner or husband?
Yes, we have
Okay,
been.
stop right there. I just asked that question.
Yes.
So you may contact him for one reason and one reason only, and that is to arrange child custody or child visitation with your children. But if we have any indication that you've talked about the facts of the case or made any threats or done anything other than basically talk to him or the family about visiting your children, you'll be back in jail. Do you understand?
Okay.
All right, that will be my order.
All right, ma'am, you can have a seat in the back.
Latricia Prothrow.
That was a P, Your Honor.
Sorry.
I got it. Never mind. Thank you very much. Sorry.
Good morning, Ms. Prothrow. Am I pronouncing your last name correctly?
Yes, ma'am, Prothrow.
All right, let me pull up your matter. Your case number, Ms. Prothrow, is 25 CR 12162. And it looks like you were charged on August the 18th, 2025 with displaying bogus vehicle registration plate or title. Did you understand that charge?
Yes, ma'am.
And how do you wish to plead to the charge?
No contest.
And you understand by entering a plea of no contest, the court will find you guilty of the registration charge?
Yes.
Yes?
Yes.
Thank you. You have to be a little bit more clear so I can pick it up on my recording. Did you understand your constitutional trial rights, Ms. Prothrow?
Yes, ma'am.
Do you have any question about your rights?
No.
You understand that this is a misdemeanor offense for which you could be sentenced up to 6 months in jail and fined up to $1,000?
Yes, ma'am.
And have you served in the United States military?
No.
The court will accept your plea of no contest as freely, voluntarily, and knowingly entered. Why isn't your car registered, Ms. Prothrow?
I don't really drive this vehicle, so I was taking my fiance to work because we were planning on selling the vehicle. So that's why. Yes, ma'am.
So can you get it registered?
Yes, ma'am.
Okay. What I'm going to do then is I'm going to fine you $195, but I'll give you, how about 60 days to get your car registered, and I'll reduce the fine by $100.
Yes, ma'am.
All right, so I'll fine you today $195, but I'll stay the imposition of that sentence for, is 60 days enough time?
Yes, ma'am.
All right, by October the 20th, you need to provide proof that your car is registered, and I'll reduce the fine down to $95. Does that work?
Yes, Your Honor.
All right, then based upon your plea and your agreement, I need for you to go over to the Reno Municipal Court. I'm going to release you today, Ms. Prothrow, unless you have other matters in other courts. But as to this court, you'll be released to go over to the Reno Municipal Court and sign that agreement that I've made with you to reduce the fine upon proof of registration, okay?
Yes, ma'am.
All right, that will be my order. Do you have any questions?
No, Your Honor.
All right, good luck.
Thank you so much.
Nicholas Stone.
Good morning, Your Honor.
Good morning, Mr. Stone. Your case number is 24 CR 07137. this is set as a revocation hearing. I'll go over that with you now. It looks like on June the 4th, 2024, about a year ago, you were charged with simple battery. You entered a plea. If you were found guilty, you were arrested recently. It looks like you were arrested for violation of a condition of your suspended sentence. I'm going to look at the outstanding warrant and give you an idea. You and I have both an idea of why they're seeking revocation for you.
You're saying I haven't checked in since January, which I have.
All right, hold on a minute. I can't see. I don't see a warrant here. Can someone enlighten me as to?
If I may, Your Honor, I didn't see a warrant either. I know that your court clerk advised me that he has two separate other cases with pretrial dates on 9/23. I will note that he was supposed to do 14 weeks of anger counseling. He's only done 2 of those classes. My assumption was the new charges he's picked up and the fact he didn't do his counseling would probably be part of the warrant, but I didn't see a warrant.
Thank you.
And I can give a little bit more information.
It
looks like he had one prior violation. He had a trespassing case in February of this year where it was alleged that he had punched himself in the head. It looked like maybe he wasn't taking his medication, and that's what was the issue. And that's the reason he gave at the time for not doing his classes. But at that point, he did say he would do his classes and would comply from here on out. He was reinstated at that time, and that was February.
And what's the underlying sentence for the simple battery, please?
Let me check. He was sentenced to 179 days suspended for 2 years, obey all laws, no contact with victim, 14 weeks of anger management. And then it looks like, Judge, I don't know if it was you, but a status hearing was set to provide proof he was enrolled in anger management. The violence in this case is he had punched somebody in the mouth because he thought that his driveway was being blocked. His history includes a felony inflicting corporal injury on spouse. He went to prison for that. He's had several anger issues in his history, unfortunately.
Thank you. Do you want to add anything, Mr. McGinnis?
Without an active warrant listing what all the allegations are, I'm not really quite sure how to proceed going forward. I know that he has a pretrial date on 9/23 for his 2 new charges.
Well, obviously, every suspended sentence in our court is based upon the first premise that the person obeys all laws. So even though he has been charged, he's presumed to be innocent. Being charged with new offenses is a matter of concern for the court, and more based upon, probably more pointedly, the fact that he has a lengthy history of violence, the fact that he was ordered to complete anger management and has not done so yet is of grave concern to the court. So
let me more information. Sorry to cut you off, but it looks like he has a citation for a domestic battery arrest that he ended up getting charged with simple battery. So maybe that's the new case for which he's here for. So it's not, that's probably why he's in custody. And
what's the date of that citation, please?
The date of that citation is August 18th. So just 2 days ago, it looks like he was arrested, and arrested for domestic, charge was simple. And I'm looking at the case file here. it looks like the incident is alleged to have occurred on August 13th. He was arrested a few days later, but it was alleged that a female was being choked by a male. So that's how it was reported. That's the case that's still pending. But so that's.
All right, I'm inclined to do this, so everybody is on the same page. I'm inclined to hold Mr. Stone with bail for a day or two so we can get all the documents and facts in place and see whether or not revocation is warranted in this matter. I know that there's already been a record that he's clearly in violation of his suspended sentence by his lack of completion of his anger management class in such a long period of time, as well as obviously new arrests. So I'm inclined to continue this out till tomorrow or Monday so we can have a clearer picture of what Mr. Stone, what he's done and what he's charged with and what the Marshal's Division relative to supervision has to say. So does anyone have any objection to that course of action?
No
No
objection.
objection.
All right, so Mr. Stone, I'm going to continue your matter till Monday so I can have all the new facts of what's been going on in your world. Please note, though, that you should be seriously considering the fact that you could be revoked to that 179-day sentence based upon your lack of compliance with the court's order to complete your anger management, okay?
I understand that, Your Honor, and I do apologize for the lack of the completion and everything. I've just been going through a lot of hardship. I just recently regained employment with LaborMax, and I was going to be getting back on top of my classes. Unfortunately, there's been a little speed bump in the road. Things like this are not planned, but I have been trying to thrive towards the reconsolidation of my relationship so that we could move forward and actually be a productive couple instead of having these. So I would like to say I appreciate you pushing it out so you can gather the facts, and I appreciate your consideration on the case. Thank you very much.
Thank you, Mr. Stone, and obviously any efforts you've made to stay out of trouble will be taken into consideration. It is of concern, though, that you're charged with reoffending or breaking the law. So that's something I want to clarify before I make any decisions in your case.
Yes,
So we'll continue your matter. Does the city wish to be heard as to bail?
Your Honor, the city would request a $5,000 cash bail based on the lack of compliance, the violence, the new charges. I just looked up looks like the pretrial, I'm sorry, it's a bench trial because he was charged with simple. It's set for September 30th of this year. But the city is very concerned about the danger to the community and the victim.
Thank you. Mr. McGinnis, do you wish to be heard as to bail?
I'm just concerned that his court date's pushed out till September 30th on his other cases. I don't know if are we going to consolidate everything? Is that kind of what we're looking at?
No, I wasn't inclined to consolidate, but I think that everybody needs to know what the new charges are. And I'd like to hear from the Marshal's Division relative to any other supervision issues that we might need to be aware of, including the fact that obviously he's admitted that he's only done 2 of 14 anger management classes, but he has, if the new charges involve drugs or alcohol, I want to know about that as well. So I think that we need to be all fully informed before we make any decisions as to whether possible revocation.
Thank you, Your Honor. I'll submit it based on that.
All right. So I'm going to go ahead and set bail. It would be $5,000. It's going to be bondable. So Mr. Stone, but if you are able to bail out, the conditions of your release would be that you obey all laws. You have no alcohol or drugs without a valid prescription, including marijuana, and you have no contact with any alleged victim, either the new cases or this old case that's a simple battery. Do you understand those conditions, sir?
I do understand, but that is not reasonable bail for me. I already have $2,500 on the case that I was arrested on, so that's like really making it impossible for me to be able to get out and get back to work and to be able to do my classes. I don't know if there's any way that I could request an OR or just a bail reduction, but that is making it very impossible for me to be able to get out. I also know for a fact that the victim did not want to press charges. I understand that in the state of Nevada, that when it's a domestic allegation, a party does need to be arrested. But I do know that the victim is trying to get the case dropped and is doing all that they can.
Well, we're going to address all those issues on Monday. In the meantime, over the weekend, your bail will remain in effect at $5,000 bondable. We'll have more information on Monday when I readdress your matter, okay?
Okay, I do appreciate that. Thank you very much.
You're welcome.
Okay, folks, it's a couple minutes early, but this is honestly a logical place to leave it for today at the end of a hearing. I hope y'all had fun today. We got to go to a couple of new places, spend some time in DeKalb County, Georgia, and then obviously in Reno here, and I think they were both winners for the most part. So, yeah. One thing I did not do today was shout out this channel's sponsor, Aura. Go check them out, aura.com/TCF. There's a link in the description. You get 2 weeks free to try them out. You'll be amazed at the places where they find your data online, and they will start removing it for you. And quite honestly, it's 2 weeks well spent. So aura.com/TCF. There's really no reason not to go give them a try. If it's not for you, no big deal. Cancel. If it is for you, you'll be happy with them. Either way, you come out on top. So give them a look. We'll be back here tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. And tomorrow's Thursday, so we'll have sidebar tomorrow night too. And that will be fun as well. Have yourselves a good Wednesday. And take care. God bless.